export order.
Yes,
We'll take it on priority after 2 weeks. Yes.
my lord, may be taken up on Monday, he is saying.
No, we are not free because you are unfair to me. Yes, next.
No, my lord, I may be pardoned for
No,
that.
no question of pardon. Call after 2 weeks. Yes.
Item 1.
Face Mr. my lord.
Insolvency proceeding I am facing, my lord.
It will
My assets will be liquidated by the timely week.
next week. Yes.
Item 1, we have
Yes.
but which copy they have solved. Page mark has not been made and annexures are not made.
You return.
Yes, but
You return it.
We'll give a press box.
How he should argue? First of all, we are under
apologize.
pressure. And you also will be under pressure.
Yes, your lordship,
You-
even our official records do not have all the documents. I will.
But we do that. Do that.
Yes,
Do that
yes, your lordship.
next week.
I will serve a fresh
You
copy.
will have it next week.
Yes, my lord. 1 week after let them copy this out.
Yes, I'll serve a copy.
Serve copy. It was copy of the SO with correct paginations and with all documents. Yeah.
Okay.
On the council appeal for respondent. Next, call of 2 weeks. Yeah.
Item 2.
Item 2, my lord, on behalf of Mr. Sankar, my lord, kindly taken up to each chapter, my lord. Day paper yesterday, his father was died, my lord.
Of 2 weeks.
Yes, in the meantime, I am saying.
Next.
Item 3.
On the ground of bereavement in the family of forgiving cause. Yes.
Item 3.
Ranjan Kumar,
challenging the order of the Honorable Single Judge, my lord. And another matter also pending before this Honorable in WS.
call along with the
175.
number.
This may be
Give
listed.
that paper.
Yes, this will listed, my lord. This is
You
Monday.
have said it.
Yes.
Still you want to argue?
Monday, my lord.
Yes. Yes.
1745.
Next.
Item 4.
Yes.
Sir, my lord, in this present date appeal, limited question of my lord. The election petition filed by the defeated candidate with a delay of, my lord, 8 days.
EP is filed, the time board EP.
Yes,
No provision for condemnation?
there is a provision for condemnation, my lord. Yes.
Limited or unlimited? How many days condemnation?
If the 15 days time is for within 15 days he has to file, and after that it is the discretion of the court to see the cause and to condone the delay. In this present case, what happened, my lord?
Which is that section?
That is, my lord,
Gram Panchayat Act.
Panchayat
Samiti Act 44B. In this case, my lord, what happened, my lord? The dates are very relevant. The election miscase was filed on 22/2/2022.
22.
2/2/2022.
EP number?
EP miscase number 11 of 2022.
21st March 2022.
Filed on?
May I be corrected, my lord? The election was held on 22/2/2022. The election miscase was filed on 21/3/2022.
Election was held on?
February 22, 2022.
22. And is it a miscellaneous case?
Yes, miscase. Election miscase. It was filed on 3/2022 with a delay of 8 days. Admittedly,
21/3/22.
my lord. With a delay of 8 days, admittedly.
1 second. What is the limitation period?
15 days.
15 days.
My lord.
Not 30 days.
No, my lord.
Which is that section?
That is 44B.
Read.
That is, my lord, the petition shall be presented on one or more of the grounds specified in section 44L before the civil judge having jurisdiction over the place at which the office of the Samiti is situated, together with a deposit of 200 rupees as security for cost within 15 days after the day on which the result of the election was announced.
After the date.
After the date.
Date of announcement is excluded
Yes,
because it is after.
yes.
So even then it is time barred is over.
It is, my lord.
Delay-
My case is that, my lord.
Delay,
My lord?
read the section fully.
Yes. Provided that if the office of the Civil Judge Senior Division is closed on the last day of the period of limitation, as aforesaid, the petition may be presented on the next day on which such office is open. Provided further that if the petitioner satisfies Civil Judge Division that sufficient cause existed for failure to present the petition within the period aforesaid, the Civil Judge Senior Division may, in his discretion, condone such failure. Provided also that in cases where the result of the election was announced prior to the 26th day of January 1961, the aforesaid period of limitation shall be computed from the said date.
That may not be applicable.
And other parts are not applicable. Here, my lord, my case is that, my lord, the election miscase was filed on 21/3/2022
Correct.
with an admitted delay of 8 days. But, my lord, the election petition was not accompanied by a limitation application. And after the petitioner, the appellant appeared before the learned trial court, filed his objection. Thereafter, the limitation application was filed on 29/9/2022, which is around 6 months of filing of the main application. So my submission is my lordship before is that delay should be of 6 months, not of 8 days.
Delay is of petition, not delay in filing the application.
The delay application for condonation of delay application was filed on 29/9/2022.
Where is the limitation for filing the delay application?
Limitation
The
is
limitations for filing the petition. Where is the provision which says if there is delay, then application seeking its condonation shall be filed within so many days? You want to make law something else?
the application for condonation of delay, my lord.
This is the only point.
This is the only point, my lord.
That's which is ILR 1986 Karnataka. DB. Take out. Anything you want to say? Why the
I am for the OP one. Apart from they have three legal points. That is, one is that no.
He is arguing only
one point.
Wait, 3 points. How can we take up other points when he confines his argument to 1 point?
My submission, Your Lordship, is that there is no need to file a separate petition for condonation of delay, as the section doesn't provide for a separate petition. It only states.
Have you mentioned it in your petition itself?
Yes, Your Lordship.
Election petition you
You have the copy of appeal memo.
No, your petition.
in your miscellaneous petition.
That may not be true because of subsequently your
In the
application also.
in the 5th paragraph of the miscellaneous petition,
Annexure 1. One series.
in Annexure 1 series,
He has mentioned that there is a delay of 8 days
8 days.
in the petition.
Courts have already held. 3 high courts in the country have held. If an appeal or a proceeding is filed time barred and there is a provision donation of delay, the appeal or proceeding cannot be thrown away. In such an event, the registry should point out that there is delay. Court should give an opportunity to explain delay. Then if he does not explain, your contention will be not matter. Take up. What happened now on the main matter you have come here?
Yes,
Main matter is Mr. AC decided against you.
Man.
No other point.
No one.
On merits it is held in against you.
Yes,
By the original court as well as the appellate court.
man. And also by the Hon'Ble single judge. This is the only point.
That's right. You have put forth very effectively. This case, kindly be seated. Kindly be seated. This case has a successive stage. Seventh. Originally, it was filed before learned civil judge
It
in
was
a division.
learned senior civil judge Karanjia.
Senior civil judge Karanjia. Wide
Election
election miscellaneous number 11 of 2022. Then it went to whom?
Then I lost there. Then I carried an appeal to the court of the district judge, District Judge Barikota.
The
At moment.
election having been election petition having been favored, comma, the election of returned candidate was settled. Wide order dated
The election miscase order dated 9th April 2024.
27. Then appeal was carried to
To the
the
additional
court
district,
of
additional district
district
Karanjia.
Karachi. In appeal number?
Election misappeal number 2 of 2024.
Miscellaneous appeal number 2 of 2020. That came to be dismissed on
30th September 2024.
first. Thereafter, the returned candidate preferred WP number
WPC number 27807 of 24.
24, which came to be negative by single judge of this court wide order dated 26/11/2020. First of all. Now, in the appeal, comma, matter is at our hand. Next one. Learned counsel appearing for the returned candidate who suffered cancellation of his election, vehement or just one single point for our consideration. One. An election petition filed belatedly has to be accompanied by an application for condonation of delay and therefore an application filed subsequently, in this case 6 months, about 6 months, could not have been entertained by the election court. And he further argues that this important aspect having not been adverted to in a correct perspective, the impugned orders are liable to be set at naught. First, kindly be seated. Learned presenting the respondent makes submission in justification of the impugned order and the reasons on which impugned orders and the reason on which it has been constituted. First, having heard learned counsel for the parties and having perused the appeal papers, we decline indulgence in the matter. Broadly agreeing with the reasoning of the learned single judge, who has affirmed orders of the courts below. First one. Next point. Section, which is that section?
44B of
Can you
the.
be seated? Can you sit and answer?
No,
We're on par with each other.
it looks
That's all.
very. 44B of the Panchayat Samiti Act 1959.
Section 44, capital B.
Capital B of the Panchayat Samiti Act 1959.
From Orissa Panchayat Samiti Act.
Madam.
Of which year?
1959.
1959. Prescribes a period of 15 days as a limitation. laying a challenge to the elections to panchayats. First, the period is reckoned from a day after the election results are announced. First up. In the instant case, the challenge was laid on 21/3/2022, and thus obviously after the period of limitation. First up. An application is filed long after filing of the challenge seeking condonation of delay. First up. Counsel for the respondent rightly points out that in paragraph
5 of the
5 of the election petition, in the miscellaneous petition, delay is mentioned. First up. Next one. The provision of section so and so also provides for condonation of delay. First up. This provision does not say within what period an application for condonation of delay should be filed. First up. This is a matter relating to law of election and the apex court in Jyoti Basu versus Devi Prasad Ghoshal, AR 82 SC so and so, has an election law is what the statute says, and no other principles will be applicable. First, thus, the first contention that the petition challenging election when filed belatedly has to be accompanied by an application for condonation of delay is liable to be rejected, no provision having been made in the statute prescribing any filing of such applications. First, a division bench of Karnataka High Court in ILR 86 Karnataka so and so has held that a proceeding filed belatedly cannot be turned down on the ground of delay per se without giving an opportunity to file an application for condoning delay. First one. Next one. AR 86 Karnataka 179.
44 is the present person. 44 DL upon delay.
Not this, it is a justice Venkatachalam. That's one. No other point having been argued, this intra-court appeal is liable to be rejected. But, and accordingly it is. Yes.
Item 5.
Item kindly be taken up next week.
2 weeks at the request of. Next.
Item 6.
None appears. Call after 2 weeks. You are here? Counsel for the CGC. CGC is not here. Counsel representing the Union government is absent. Call week after next. Next.
Item 7.
Seven.
In this matter,
Yes.
Limited grievances before the lordship. We taken to the provision of the service act. My lord, I am the debtor
How much?
as well as the
What is
mortgage.
the debt?
My lord, 3 crores 59 lakhs as per the demand notice, my lord.
Demand notice dated.
Demand notice dated, my lord. 11th July 2022, my lord.
11th July 2022. It will be how much?
My lord, in this matter,
No, we're asking you. You have to answer first. We want to know the conduct of the party because we are in this jurisdiction.
my lord, I am telling you, my lord. Good 1 minute, my lord.
You are already in essay, no?
ESF 55 by 2025 is pending. Another rate is also tomorrow the matter will be listed, my lord.
Not necessary.
In this particular case, my lord, I had filed an application before the DRT for consideration of an application, sub-rule 8 of Rule 8 of the SARFASI Act, telling out the property in question by a private entity. Law provides, my lord. Other
that
than
also.
public tender, and this is the provision.
Anyway, that application is
Yes,
considered.
yes,
Direct them to consider.
yes, my lord, your lordship kindly dispose of the.
I have instruction to appear for the opposite party bank.
Any objection for direction to consider the application?
Let it be considered on its own merit.
Shorn of the textual prayer in the petition, learned counsel for the petitioner borrower very fairly submits, and learned panel advocate appearing for that with equal fairness agrees that the DRT Cuttack may be directed to take up petitioner's application in INM application number anything.
I had diary number 139.
Slowly. He should write now. Slowly.
Sorry. I had diary
number
1394 by 2025.
1394 by 2025.
25 and
in filed in
Essay.
in SF 55 by
essay number
my lord
55 of
2025
2020.
and I had diary number and
Same in the same essay.
yes, me
And I so
diary number 2060 by 2025.
filed in pending essay number so this it should come like this. Both in both them. First. Then next paragraph. In the above circumstances, petition is disposed of, requesting the learned presiding officer of the to take up both the IAS for consideration within an outer limit of 6 weeks. All right? 8 weeks. 8 weeks? 8 weeks. First, all contentions of the parties are captured. Disposed of. Next. Item 8. Which is that another matter you are saying?
Tomorrow the matter is
Well, it will tell them to bring it here right now.
Here, my lord. Also, the interim order not compliant.
Anyway,
application
we
number-
are telling them to dispose of the application. All contentions are kept.
Application number 654
by
26.
You
Write it and bring it. In that, what you also.
My lord, there is a direction to deposit the 50% of the amount of debt demand notice amount that which comes to rupees, my lord.
Have you deposited?
My lord, today the last today the
Then put it.
89 lakh 71,080.
All right, it will come tomorrow. Yes, next.
Number 65.
Item 8.
My lords, this is appeal by the state.
Yes.
There is delay of 186 days.
Yeah.
My lords, here, my lords, the petitioner, the respondent, present respondent, was brought to the regular establishment in 2018, my lord. And after 1/1/2005. So, my lords, the pension rule not applicable to the,
Calculate the minimum qualifying service period of the petitioner, taking the shortfall period from the service period of the petitioner
my lord.
as work charged employee.
My lords, work charge he was appointed on 14/1/2011. This is also after 1/1/2005, my lord.
He was appointed, initially he was appointed when?
Initially, he was appointed 83 as a DLR.
83.
My lord.
Nothing.
DLR basis, my lords. My lords, rule applicability of 2005 rules, my lords. Rule 3(4), my lords.
Yeah. He was on 14/1/1983 entered service.
8/7/1983.
8/7/83.
My lord. Are you a typist?
All right. You were as a junior typist.
None.
And he was brought on
What charge establishment, my lord?
14/1/2011.
And regularized 30/10/2000.
1 second. 14/1.
2011. Then regularized, my lord, under regular establishment on 30th October 2018. Retired on 30th June 2023. And in very same identical case of same department, your lordship disposed of the writ of appeal.
We have that.
Yes. And my lord, I am also forwarding the order of the learned single judge in this case.
Give copy to Mr. Dehuda also.
Yes.
When 3 is already considered in this judgment.
My lords,
3, I read with 18(3).
my lords, 3(4), my lords. 3 subsection 4, subrule 4. The applicability of the 2005 rules, my lords. Notwithstanding anything contained.
Lordship may kindly see para 4 of your lordship's judgment, my lord. Very same
I
department.
have identical question, identical rule is considered.
And DLR on 1985. What charge 18/1/2011.
Better. This much over this. This intra-court appeal by the state and its officers calling question a learned single judge's order dated 4/10/2023, whereby respondents WTC number 31/6 of 2023 having been favored, relief has been accorded to him as under him or her. Him as under operating question. Next paragraph. Appeal is filed after booking a delay of 186 days, and an application is moved, supported by an affidavit in IA number so and so, seeking its condemnation. First cause. We have not come across one single appeal of state filed without a broking delay. Be that as it may. First cause. You agree that delay be conducted? Learned counsel appearing for the respondent very fairly and appreciably submits that the subject application be allowed and delay be conducted. First, we do it, and accordingly, IA is disposed of. Next paragraph. The subject of this appeal is substantially similar to the one in writ appeal number 975 of 2025 between Principal Secretary to Government versus Ashok Kumar Pattanayak and another, heard and disposed of by a coordinate bench, wherein one of us, by this bench, while order dated 12/1/2026. First off, the state appeal was dismissed in the said case, and therefore, this appeal by the state has to meet the same fate, there being no repugnant position, and all contentions relating to rule position having been dealt with. First off. Next one, ordered accordingly, and writ appeal is dismissed. And on what period you are going to implement the court order of the learned single judge?
My lord, 2 months time maybe.
Order of the learned single judge shall be implemented within an outer limits of 2 months, failing which contempt action would follow.
My lord, may I pray one line, my lord? In this case, my lord, present case, he has been brought over to regular establishment. Here he has not been brought over to regular establishment. There is a direction to regularize, but I am already been regularized.
You have been regularized. So in a better position than
Yes,
other case.
yes. That param,
We need to mention that.
my lord.
One sentence, same fate. But first off, learned counsel appearing for the respondent is justified in telling that the case of his client is far better than the cognate case, in as much as his services were regularized with effect from 30 October 2018, and he retired on 36/2023. Okay.
Item 9.
No problem.
9, my lord. Let it come next week, my lord.
No, pick up to next at the request of
All 4 cases are next week.
all four.
Item 10.
Yeah.
Item 10,
Yeah.
my lords, kindly see
Ah.
the order at page 26, my lord.
Para number?
Page 26,
It begins at 26.
my lord.
Ah.
3 paragraphs only.
Analogous to 8489 of
My lord,
2023.
against that judgment, that is writ appeal pending.
I am giving the numbers.
Pending. That we will post that matter. How that, which is that matter?
No, date has been fixed, but these are the batch of cases I am giving.
We will bring them all.
Yes. This same.
Yes.
The main case I
All this matter along with the writ appeal number so and so next week.
My lord.
Okay. Next.
Item 11. 2 batches I have given.
Yeah.
2 different batches.
Ah.
Item 11.
I am
Yes.
for the respondent.
My lord, say 11. In fact, I'm not ready.
Not ready. You will have it next week.
Yes.
Call next week at the request of the DG. Finally. Yes.
Item 12.
Intra-court appeal on behalf of the state.
Yeah. Anything is there?
My lord, that is a delay in the first part. It is 103.
103. Will
Yes.
confirm delay. Agreed.
And so far,
What is
and
the matter on
so
merit?
far the merit is concerned, my lord. Here there was a advertisement.
Advertisement dated?
It is on 17/7/2013 by the OPSC for the post of assistant engineer.
Assistant engineer electrical.
Yes, my lord. Though initially it is for 38 number of posts, but subsequently by virtue of the court's order, so 9 posts kept reserved.
So 31 it is reduced to.
So, 11, it is come to 29 total posts.
29.
29 posts.
All right.
And accordingly, merit list was prepared. So by virtue of the court's order, only 29 posts is to be filled up, and taking into consideration the reservation policy.
Another WP.
another WP, another OA, WP, OAC also. 3 applications are there.
Okay. Then what happened?
Then, my lord, keeping in view the reservation policy, it has been serially, it has been on merit, my lord. Merit list was prepared, my lord. Merit list was prepared. 1, 2, 4, 12. They did not join, my lord.
1,
2,
4 and 12
4 and 12.
in the merit list.
Yes, ma'am.
where you are.
You are category. Your category that they belongs to SCBC. But on merit they have scored the found place in the merit
category at all. Because of
their
Sahani.
merit, Indra Sahani, because of their merit. Accordingly, the present petitioner, I am to say present respondent, my lord, he belongs to SCBC category.
Which
Who is found place in serial number 14. My learned friend is there.
SCBC.
My lord, I'm begging apology, my lord. Can I interrupt, my lord?
For giving that.
The entire thing, my
No,
lord.
we should allow the government advocates to because
No, I'm not addressing your lordships. This document, if your lordship will have at your lordship's hand, even if it is part of the record,
give that.
that will
help his argument.
that will clarify the entire issue at the face of it. I'm sorry because I am providing one copy.
No, we will not. Next, it will not receive one copy at all. We have 2 judges. Yes.
But that is part of the record. Sorry, I'm sorry.
Yes.
Well, the petition and the writ application was found place in serial number 14, who belongs to SCBC category.
Yeah. Is serial number 14.
14 in that particular list. Belongs to SCBC category.
Well, let me see. I am provided.
Because of the 1, 2, 4 and 12.
Yes, they are part of the record. Yes, Annex of 13.
1, 2, 4, 12.
1, 2, 4, 12.
1, 2, 4, 12.
So 2. 4, 12.
You are right.
He is in 14.
He is in 14.
He is in 14. He is claiming for rearrangement of his status against
Rearrangement of ranking.
his
Status or ranking?
ranking against the post which is remain vacant because of the non-joining of the candidates.
Whether reservation is post-based or vacancy-based,
This is a vacancy based.
then he is right. If it is post-based, what you say would be right because of Nagaraja versus state.
That is a Nagarajam.
But this is
This is my post.
Huh?
Because
Show
in
the-
your category,
show the rule.
That I have quoted, my lord.
What it says?
The details provision, though not quoted in the amount of reservation, the percentage of reservation, and the post held, that I have
Question
quoted.
is not that. This point is no longer a centigram.
Yes.
If it is post-based, it will run along with the post only.
Yes.
If it is vacancy-based, then all that will not argue.
Yes.
It will not help. It will not help you. You can argue, we'll hear you. But more the argument, more will be the cost.
No.
Yes. The public, we have to ration our time.
No, I am conscious.
Yeah.
Or else be ready with that provisions and I will quote it before my lord.
Next week.
My lord,
Yes.
Item 13.
My lord, I am a cavator here. They have not supplied the copy here.
Give him copy.
Okay.
In course of the.
Next week we'll have it.
My lord,
When this matter comes.
yes, ma'am.
Yeah, same thing. Okay.
On not 13. No. Not along with 13. I am
No, not along, on that day.
Yeah, Lordship, on
So that it will be easy for you for rest of the days you can go on roaming.
on Tuesday. Can I request your Lordship for
Yeah.
Tuesday?
Tuesday. Both of them. Tuesday. How many matters are posted on Tuesday? 1 minute, please. 6 matters are posted on Tuesday. Then we'll have it on Wednesday.
Fourth, my lord.
Okay. Yes. Do you remember? That is, I think that.
Sir, my lord, is the state appeal having the delay of 230 days, my lord.
Yeah. You give 4,800
20
to
rupees.
him. Then we'll consider your this one. You give that. Can you bring that order? Huh? Subject to payment of 800 to counsel, to the respondent, to the counsel appearing for the respondent. Yes. This amount to be paid within 2 weeks, which highest and rejected, and as a consequence, appeal also. Next. Item 14.
May I please your lordship?
Yeah.
Your lordship, only 2 days delay.
2 days delay.
My lord.
On merits, what is delay?
My lord, here your lordship, due to sickness of your attach the medical certificate, your lordship.
No problem. We are condoning delay, but on merits, you said.
Yeah, my
we have
lord.
to issue
My lord,
a
I'm placing your lordship.
Yeah.
This is the application. This is the appeal memo before your lordship. The challenging the order of my lord, single judge, your lordship. My lord, the relevant person is under annexure 1, your lordship. I'm placing 5-1. Since the petitioner was never appointed on a contractual basis and instead he was appointed on ad hoc basis by the order dated 21/4/1999, his claim to be get benefit of regulation in terms of resolution subject is completely misconceived and no illegality can be found in such rejection. My lord, I was appointed existing vacancy in the year 1999.
99.
My lord, my similar situated employees were also regularized.
Others are regularized.
Regularized, your lordship. Annexure 3 and Annexure 4 of the writ petition, my lord, kindly peruse.
Is it?
Yes.
That is denied, that benefit is denied only to you.
Only to me, my lord. Thereafter, I approached the Honorable Court and the Honorable Court directed to consider my application within two months. That was also rejected by the director. Again, I filed this writ application before lordship.
But learned judge, please kindly come to page 15.
6.2.
Why I'm placing your lordship? Why I'm filing this? Next para?
6.1, 6.2.
6.2.
Learned judge has given liberty to make
file
a
a
representation.
My lord, my humble submission, I twice approached to the director. He intentionally rejected my application on the ground that I have not taken into the consideration for the illegal appointment. But I was appointed at the deck worship in the year 1999. My senior situation person applied regularized. Twice my application rejected. However,
How the others are regularized?
My lord, that has not been agitated so far this.
No, they have taken up. No, he has produced it as a document in the writ petition.
But the operating part, my lord. Exactly, my lord.
Therefore, he is before the division bench now. Why he should make one more application? Since 1999, he has been working.
99 on ad hoc basis, my lord.
Correct, but others who were on ad hoc basis have been regularized.
They are against the contractual. They are saying so far the para 5 is concerned. Completion of 6 years in the contractual post,
Yeah.
they have been considered.
Yes, he also should have been.
My lord, he is in different footing. As it appears from the page 14. Para 5, my lord.
para 5 ko. In the case of Dharampal,
And 5.1. Since the petitioner was never appointed on a contractual basis, and instead of he was appointed as an ad hoc basis and such and such.
How can they discriminate?
No, you cannot discriminate from amongst the category. Where is the others, the document which shows that others have been,
Annex 3 and Annex 2 and Annex 3, Your Lordship. It's not giving the return. Read.
No, that is the, Annex 3 is your, wait,
OA, that was as per the order, Annex 2 is the OA, that was as per the order of the Honorable Stat. They are regularized. And Annex 3, it is my application, Your Lordship. That was his Annex 3. That is not considered. I'm giving Your Lordship. Annex 1, Annex 2. Annex 2 and 3.
so this order of OIT has been complied
My Lord.
in Annex 3.
2 is the my similar employees are regularized and 3 is that was directed. Take that.
the same material. No, waiting, we have this, we have this. Fine. What do you say? Who is there? You are the
Other side is the government.
huh?
Other side is the government.
Government. Admit this and call this after 2 weeks so that you will have the
Along with the writ application.
which writ application. No, that's already allowed. House. 2 days delay. Is condoned in 22 days delay is condoned in terms of application in IN number so and so, which is supported by affidavit. First time, having heard on the counsel for the appellate, we are of the considered opinion that matter requires deeper consideration. Similarly, circumstantial persons have been given the benefit of regularization, whereas it is denied to the appellant. First, call after 4 weeks. Be sure that the AGM is to complete such that it's not call after 4 weeks also.
That.
Item 15 has been disposed of. Item 16.
Yeah.
I have already handed over the house number
You have handed over the position.
and I have.
Yes,
I'm
you have taken the
fighting-
position.
I have been informed by the bank. Yesterday they have taken position.
This is.
Are you filing the affidavit?
Yes, ma'am. My lord, in this affidavit, when notary put this date, it was 30.
Ah. He is 1 day advance. See, now that even Justice Chandrachud's judgment, which you have cited, in one paragraph, it has given left a small keyhole. If now they have shown the not even borrower, he was only the auction buyer. But no fault can be attributed to him as such. Okay. Though the forfeiture happens by operation of law on the basis of the judgment which you quoted, Lord Justice Chandrachud, Honorable Justice Chandrachud's judgment. Even that judgment itself gives a keyhole where you can consider the request rescinding of the forfeiture. There is such a paragraph. I read that. Just look into that.
and we have also come across a case where on mediation you have written.
Not only this, day before yesterday, we came across a case where bank went for mediation, and in the mediation they agreed to rescind the forfeiture and give the amount back. Not entirely, but some amount can be, it's a huge amount which was invested for buying the property in auction. And the case was going on. Decree was passed. How can you expect a person to buy a property in respect of which the title is clouded? Not only clouded, title set aside by the decree of the court.
Milord, my submission is, before the decree has been passed, recovery of already a recovery certificate in 2012 has been passed. Yeah.
That's true.
That
But
is the-
point is,
Milord.
there was a cloud on the title.
That is,
You mean to say, and you did not tell it in your advertisement.
Milord. Because
Otherwise,
it
madam
is-
said that.
yeah, because your lordship has rightly said.
Therefore, what we are suggesting to you is, instead of we only making order and directing you to give back the entire money, let her make a fresh application, saying that in the light of that judgment, and you take a call on that. Now, even the property, because of our intervention, you got the property back now.
Milord obliged.
It's a public property now, is it not?
Milord.
Therefore, you proceed against the property. What is the extent of loan?
Loan is 1 crore something, 37 lakhs.
Property will fetch you.
Milord, that valuation at that time, 23 lakhs were there. Now it would be, because at that time, 23 lakhs in 2012. No recent valuation is with us.
It will be much.
I do not know exactly the valuation, the market value, whatever it can fetch. But question is, if your lordship suggesting, then whether I can take an instruction from the bank, if they can go for a mediation.
Where is your bank?
Bank is in Bhubaneswar.
Bhubaneswar.
Milord. And if he can give a representation what your lordship has suggested and quoting the paragraph, and then they can consider for either mediation or to, if they will feel that because of this encumbrances future, if it not known to the bank, but however, our lordship, there is something is there shrouded on the property that is, now that is also damaging us, whether that will be sold or not. That is also there, sir. Because now we are going to multiple litigations. That is there because it has
The only point which you can argue is her client was in possession of the property.
So now she has given the peaceful possession yesterday by your lordship's order, and that immediately bank has taken possession. Only thing is question of 5 lakh. And what your lordship said, then we will see whether bank can receive or consider. If he can give a representation.
You keep your, you tell it that court has requested him to be present before the court, the manager, branch manager.
And then,
choose whichever date you want. Now, bona fide is shown. We cannot send bona fide litigants back without some Rasgulla.
Milord, I'll suggest, Milord, by February 6th, Milord, you will keep that.
Call this matter on February 6th. At the request of the panel councillor.
So your lordship may direct the branch manager.
First, the branch manager is requested to be present before the court to assist in the proceedings, in as much as the petitioner, petitioner has handed over the peaceable possession of security property yesterday to the bank. First time. To that effect, petitioner has filed a affidavit dated 29/1/2026, which reads as under. You just quote it. Yes. Let it be a document.
Milord, the writ petition which has been filed 2025, by virtue of giving possession, it is infructuous. Your lordship can dispose.
That writ petition will be
disposed of, and only
WP number 3607 of 2025, in view of this development, has been rendered infructuous and accordingly is disposed of. First time. Call WPC number 13711 of 2012 on 6th
February.
6th, we have a difficult time.
Milord, then you may 10 or 11, whatever February.
On 10th. On 10th.
Milord.
Can I submit my lord on 10th? If I may be allowed, I want to show my lord annexures.
No, you can show not 2 minutes.
With judgments, my lord, which has not been taken into consideration.
That argument is not available.
Now it's considered.
That amounts to saying the High Court can decide. No, because there is some judgment.
Yes, ma'am.
Though Rupert Cross says, he is a president in English law, a judgment which does not take note of another precedent is a judgment silence of silentius.
Silence of silence.
But that ground is not available to the High Court. not to follow the judgment of apex court. Apex court says, if there is conflict between two judgments of the apex court, the later judgment should be taken as the correctly law. That's how the apex court has said. It's in variance with English law. It's okay.
May I apologize, my lord?
Yes, yes.
Item 6, where the
Six, sir.
petitioner. Lordship is non-appear adjourned because I will not stand with the lordship. I keep the next week because
Recall that and say, call next week at the request of learned DST.
Item 17.
Item 17, I pay next week. In the meanwhile, I will file my result.
17.
Yes, please.
You are
I'm from the petitioner.
number 1 and 2 not filed. 2017, no time will be given. And yeah.
Yes, the petitioner challenges the Annexure 7, order dated 15/3/17 at page 18.
Yeah.
In which the Lord of Tribunal has rejected the original application. Fact of the case that in 1996, a panel was prepared by the opposite plaintiff number regarding fill up the post for junior
Agriculture officer
and junior horticulture officer.
Okay.
And in that process, only 314 candidates were got the appointments. And the rest, there is a provision that until exhaustion of that list, it will continue. That is the procedure they followed.
Please
Because
repeat.
yes,
Repeat.
because batch wise they have made a list, and from that list they go on given appointment. In that year, only 314 posts they have filled up, and this petitioner's serial was 361. Thereafter, in
367.
yes, Lord. In 1997, an advertisement was made by the selection board
Commission.
Yes, Lord. Because previously there is no selection provision for a selection board. First time they have entrusted that selection process to the selection board. When the process was continuing, they withdrew.
They withdrew that power and gave it to director of
Again to the director.
Yes.
In 1997, this petitioner along with 3 others challenged that advertisement. Filing way number 300, 634, 35 and 36. And Law and Tribunal has rejected the application but given a liberty to this petitioner. They will represent it to the authority which will be considered. In 2000, the government made a policy decision that they will fill up 76 posts which was laying vacant. That is reflected in Annexure page 23 million. Paragraph 5 million. Last 3 lines. During discussion, it is reveals that in the meantime, vacant of a junior agriculture officer post are increased to 76. It has therefore been decided that
you were appointed only for one year only.
Yes, my lord.
And you have been disengaged with effect from 31/3/2002.
He was engaged on stipendiary basis.
After 1 year is over.
Yes, my lord.
It was a tenure appointment.
No, my lord. That is that instead of fill up that 76 post, now what they have done, they have diverted that post to the deployment of surplus staff nurse.
No, how you are concerned?
For that reason, I filed a application before the honorable tribunal that my application should be considered for the 3 posts, because out 20 posts they fill up 73
In
posts.
fact, you have given age relaxation also.
Yes, my lord. 3 posts they kept vacant because of these 3 candidates who earlier have approached the tribunal, and tribunal have given them liberty to approach the authority to consider that post, my lord. For that reason, they have kept 3 posts, my lord. And my original application, which I have filed before the tribunal for consideration of my application for that 3 posts. That application was kept pending for years together. In 2017, it has been disposed of only. But kindly see what is my prayer in my original application.
Okay.
That is page 19, my lord.
Yeah, entire order we have read.
Yes, my lord. And second original application with regard to given a chance to sit for the selection, which was occurred in 2011, my lord. In the process,
at this length of time, nothing can be done. Nothing can be done at this length of time. What is the age of your client now?
At present, 57, my lord. 57.
57 can become now. Take care of it. Even if he is appointed also, he will not get pension, etc. They have said the tribunal has given some reason as to why it did not favor you. It may not lead to your satisfaction.
Since 2000, Lord. But that has kept pending for years together, 17 years. That was pending. And my prayer was to consider my case for that 3 posts. That's immediately.
After selection power is given to the director.
Yes, my lord.
He will do entire exercise.
Yes.
And he will notify all the posts for.
Yes, my lord.
Yeah.
But they have taken a decision to fill up 76 posts.
Correct.
But instead of fill up that post, they have diverted that.
It's a class 3 post it is. The post which you want is a class 3. Can class 3 post be given in Cuttack market?
No, my lord.
As a freebie?
No.
It cannot.
No, my lord.
There is a normative process.
Yes, my lord.
And
but
we'll see in some other case when you get good case. Heard dismissed agreeing with the reasoning of the tribunal. Yeah.
Item 18.
Petition is challenging the order passed by the Lord Tribunal under Annex 5, Annexure 6, where the claim for promotion to the post of ranger has been rejected.
Post of what is your post now?
But I am now deputy ranger.
Not now. When you went to the before the single judge, no?
Yes, sir.
Not tribunal.
No, order of the tribunal under challenge.
Order of the tribunal under Annexure 6 has been challenged by it.
What was your grievance in OA number 1105? 1105. Consider representation of applicant for his promotion to the rank of range officer.
Range officer.
From his post.
Deputy ranger to range. Deputy ranger to ranger. Ranger.
Range officer.
But while the petitioner is continuing as forester,
yes,
in 31/3/2010, basing on the recommendation of the DPC, the junior has been promoted, but the petitioner has not got promoted. So,
because adverse remarks were there.
But due to adverse remarks, which has not been communicated, petitioner made representation. That adverse remark is expunged and given as average. Basing on that average, petitioner has been promoted to the post of.
Based upon what?
Based upon this average, he was promoted.
Promoted. Because average, basing on the average, the petitioner has been promoted from forester to deputy ranger. With effect from the date, junior has been promoted, my lord, Annexure 4. Annexure 4.
Forester to
Deputy ranger.
DRO, when it was?
My lord, it was with effect from 23/8/2010, my lord, page 19, ordering part, my lord, 23/8/2010, the date junior has been promoted.
No, you have been promoted when?
My lord, give notional promotion from the date junior has been promoted.
So what is that date?
Date 23/8/2010.
That was juniors were promoted.
The authority has been considered and give promotion
to them,
to the petitioner. From the date junior has got promoted.
Notionally till?
Notionally with effect from 23/8/2010.
But you also got the promotion with effect from same date.
Similar, that is the order, my lord, page 19.
Yes.
I oppose the Lawrence Tribunal, on the basis of the order of the Lawrence Tribunal, the authority has been given promotion from the date junior has been promoted, that is 23/8/2010 to the post of deputy ranger. May I read, my lord, page 19, ordering
Yes,
part.
sir.
Page 19 is followed by page 17.
17, 18, 19. So this is the order has been issued by the
Notionally to the grade of deputy ranger.
Deputy ranger. But my lord, this same junior has been promoted to the post of ranger with effect from 29/12/2010. So
he shall be entitled to all consequential benefits.
All consequential benefits.
Then why they call it as notional?
Because since the petitioner has already been retired since 31/3/2011, and they give promotion on
with retrospective effect, therefore they treated it
only give the notional promotion
with all
consequential benefits. But what happened, my lord? The same junior has been promoted to the post of ranger on 29/12/2010. 29/12/2010. But they did.
One second. Sir. What are the rules relating to DRO to RO?
My lord.
Is it a selection post or a seniority come merit or a merit come seniority?
Sir, merit come seniority, sir.
Then how can that? You cannot lay the claim at all if it is merit come seniority.
Sir, sorry, seniority come merit.
So that you will go anywhere you want.
No, sir. Sorry, sir.
Merit come seniority with regard
to seniority, my lord.
No.
If the rule requires,
sir,
a person to be promoted as a DR or as a RO, he should put in a particular number of service, years of service in the feeder cadre, DRO. Okay.
Sir.
Then you will not get. Unless you are posted as such. Notional is one thing.
Sir.
Your actual experience is another.
Sir.
That rule will show now. Same question arose in a case relating to Rajasthan Forest Service. A notional promotion was given because it was denied to him when juniors were given.
Sir.
With retrospective.
Sir.
Then the said juniors were promoted to the next higher level.
Next level.
The rule required the experience in the feeder cadre, which they had and which your client does not have. Therefore,
the residency period.
No. So Apex Court said nothing can be done.
Sir, on 23/8/2010, the junior has been promoted.
Where are the rules? Show the rules of promotion rules, recruitment rules.
So that is sir, next week, sir, because this
after 2 weeks for producing at the request of the petitioner for producing the recruitment rules regulating the promotion. Yeah. Non-production may result into dismissal of the petition. Yes.
Item 19.
May I please, my lord?
Yeah.
My lord, the petitioner, my lord, before my lord, has challenged the order of dismissal dated 29/8/2022, passed by the Lawrence Tribunal 1017 of 2012, my lord. The case of the petition before my lord is that he, along with the others, applied for a post of face substitute under a scheme, my lord. The candidature of others considered and his candidate was not considered. So he made a representation. As no action was taken, for first time he approached the Lawrence Tribunal, my lord. Lawrence Tribunal was pleased to dispose of the way and directed to take a decision on a representation. and the original impugned order is page 29 and it is my lord.
They said Uma Devi comes in the way.
My lord. My submission before my lord that
When were you appointed?
My lord.
When were you engaged?
No, I have not engaged.
You have not been engaged at all. What is your case?
My case is for engagement under an ongoing scheme, my lord. Your lordship kindly give a glance page 30, subpara number 2, my lord.
What
Okay.
the
Page 30.
Yeah, 30.
30, my lord. Subpara 2. The original impugned order. I am placing my lord. From your biodata, it is seen that your educational qualification is BA LLB with computer proficiency in ADCHE, full stop. On the other hand, the example of 14 group D supplements quoted by you, 10 are at class 10 pass and only 4 are BA. Perhaps the general manager consider you to be overqualified for a group D posting. So, and them, what they have said finally, my case will be considered subsequently applying RB number 137/2010. So, the Lord Tribunal was pleased to dismiss my way. I carried the matter before my lord. Your lordship was pleased to quash the order and remitted back saying that BLLB is not an overqualification for consideration. Then the matter was again remitted back to the tribunal, my lord. Before the Lord Tribunal, my lord, I produced one document. The lordship kindly gave a glance. The annex page.
It's for admission now.
For final list. For page 58, my lord. This is an information under RTA Act. Which shows that.
Who appears for this?
My lord, I am the appearing for the.
Which shows that due to pendence of my original application, they consider the candidature of other 31s, my lord. Whereas my candidate is still pending. My lord, admittedly, my lord, I have no right for engagement, my lord. But I have right for consideration as the scheme is ongoing one. And by issuing speaking order, they have said that my case should be considered applying RB number 137/2010. And in the meantime, they consider the cases of 31 others, my lord.
Yes, brother, what do you say? How overqualification can be a bar? You have seen the latest judgment of the apex court last week.
My lord, taken up next to get prepare, my lord.
That is what we. Week of next at the request of the CGC.
The senior panel counsel or
Senior panel counsel. Bring that latest judgment.
My lord, may I give it that because in the meantime I became aged about 45 years.
2 weeks it will come. If it does not come, away memo. We remember. Yeah.
Item 20.
Yes. Well, there are two writ petitions. This matter relates to regulation of service.
Yeah.
The petitioner was engaged as Chowkidar cum sweeper on 1/3/1996. Several correspondences were made to give him temporary appointment. Well, I will take your lordships to those documents. Thereafter,
engaged.
I was engaged on 1/3/1996.
Entry.
Yes, as Chowkidar cum sweeper. Thereafter, several correspondences were made, and ultimately I filed way number 2077C of 2007 in the Odisha Administrative Tribunal, Cuttack Bench, Cuttack, for regulation of my service and to pay me the salary. The learned tribunal passed an order on 2007 with a threefold direction. The first direction was
way number
2077C of 2007. It was filed in the Cuttack Bench.
Way number
2077C of 2007. That was disposed of on 29/2007. I have annexed that order with a threefold direction.
20 September.
Yes, 20th September 2007. I have filed a date chart also.
What the order says?
But the order says I should be given daily wages. Number two, my lord, if there is need of work, I should not be terminated from service. Then number three, my case per regulation will be considered as and when the cases of others will be considered. So these are the threefold direction. Your lordship may I place that order? In the first case, that order is under Annexure 5 at page 24.
In the second also same order?
Yes, same order I have filed. But ultimately I have challenged the different order of the tribunal, dismissing my case for regulation on the ground that I was a part-time employee, I was not appointed against a sanctioned post, and I was engaged without following due procedure of law. That order is subject of challenge.
The other litigant is his entry point is what? This is 1/3/1996.
Yes. Both are the petitioner is one and the same in both the cases.
In both the cases?
Both the cases. Because in the second case, I have challenged the order of the tribunal. And in WPC number 27979 of 2022, I have challenged the order of the state government rejecting my case for regulation. Because, my lord, during the pendency of that case, the post of Chowkidar cum sweeper that was diverted to another district. I challenged that order before this Honorable Court by filing a writ petition. That writ petition was disposed of, directing the authorities to consider my case. Then they rejected my case. Then, my lord, another occasion also arose when, my lord, a notification was made by the state government that Chowkidar cum sweeper, peon, etc., they will be engaged through outsourcing agencies. I challenged that order by filing another writ petition. And in that case also, same number of cases I have filed. My lord, therefore, my lord, your lordship may kindly look at the date chart I have prepared in the first case, giving all the details. WPC number 27979 of 2022. May I place it?
Yeah.
37/1994. My lord, got it?
Where is that?
My lord, I have it up. 37/1994. The post of Chowkidar cum sweeper fell vacant in the office of the District Statistical Office, Khorda, which was created by the state government in P&C department such and such.
Like 1/3/96 you were engaged to that?
Yes.
3/11/99 what?
3/11/99, the petitioner filed continuing as Chowkidar cum sweeper, the District Statistical Officer Khorda, hide his letter number such and such dated 3/11/99.
On ad hoc basis?
Yes. Then, my lord, 30/10/2000.
Recommendation?
Yes, recommendation. 23/4/2001. Announcement of remuneration. 10/10/2022. Announced. Then 29/2007. The petitioner approached the Odisha Administrative Tribunal, Cuttack Bench, Cuttack, by filing OA number such and such. The tribunal wide order dated 29.
Minimum rate of wages to be paid?
Yes.
And
there is continuous need for the work.
Then don't
he may be allowed to continue in service, and regulation part is also there. Then when no steps were taken, the petitioner filed CP number 402 of 2008 in the Odisha Administrative Tribunal, Cuttack Bench, Cuttack, for implementation of order dated 29/2007, passed in OA number such and such. 21/1/2011. Instead of implementing the order dated 29/2007, passed in such, the Director Economics and Statistics Odisha Bhubaneswar, by his order dated 21/1/2011, transferred the post of Chowkidar cum sweeper from the office of the District Statistical Office Khorda to the office of the Deputy Director P&S DPMU Kendrapada. Then 2011.
the petitioner challenged the order dated 21/1/2011 passed by the Director Economics and Statistics Odisha Bhubaneswar by filing OA number 444C of 2011 in the Odisha Administrative Tribunal, Cuttack Bench, Cuttack. After abolition of the Odisha Administrative Tribunal, the aforesaid OA number 440 2011 was transferred to this Honorable Court and renumbered as WPC OAC number 444 of 2011. 2016, when the petitioner's services were not regularized, despite availability of a sanctioned post, he again approached the Odisha Administrative Tribunal, Cuttack Bench, Cuttack, by filing OA number 883C of 2016. 28/6/2019, the tribunal, upon hearing the parties in OA number such and such, filed order dated 28/6/2019, rejected the claim of the petitioner for regularization of his service and for grant of equal pay for equal work on the ground that he was a part-time sweeper and was not engaged against a sanctioned post. 2019, against the order dated 28/6/2019, passed by the Odisha Administrative Tribunal, Cuttack Bench, Cuttack, passed in OA number such and such, the petitioner has already filed a writ petition bearing WPC number 12702 of 2019. That is the second case, which is pending.
So who has now shift the post from one place to another?
Yes.
Director has done that.
Director has done that.
But under which rule?
Well, no such rule. Your Lordship may kindly see Annexure 6. Annexure 6 of the writ petition.
What is the power? Who appears for the office? What is the authority of the director to shift the post from one place to one office to another? One place to another.
Annexure 6, my lord.
Where is that power?
Under the Planning and Coordination Department, letter number 26, running phase 26.
Where is that power? Where do you tap the power?
Planning and Coordination Department, letter number 11/1/2020. That letter he has mentioned. Well, even the director has passed the order. It is pursuant to the letter of the government.
Which is that letter? Who sent that letter?
Planning and Coordination Department, letter number so and so dated 11/1/2011. One post of Chowkidar comes with the transfer temporarily from the office of the DS. Temporarily.
Then we bring back that post.
Now Deputy Director so and so Khurda to the office of the Deputy Director so and so Kendrapada in order to implement the order dated 3/9. It says, my lord, to implement the order dated 3/9/2010
if that is
of Hon'Ble Administrative Tribunal in OA pass. So, my lord.
So if that post is available now, then regularize.
No. Regulation I have to submit before your lordship.
Yes.
The admittedly
gained entry.
Yes,
1396.
Yes, 96. Ban period commences from 1993. After the ban period, ban was imposed that no temporary employment, no DLRs can be engaged in any government establishment.
But you have engaged.
But that illegal.
What action you have taken against them?
So we have, my lord, we have got that power. But we have not enforced that power now.
Where have you? If you had taken action against them, see, when there was a ban, you did not have engaged.
So many applications were filed before different forums, my lord. We had to comply with the orders of the court and fight our litigation before the tribunal.
What do you have to do?
My lord, more than 10 applications.
We do not know.
My lord,
Mr. Panda, you see, the purpose of that shifting of the post
yes, ma'am,
is to accommodate her. Is it not?
No, accommodate in so far as a temporary or the compliance of the interim order, whatever that case may be.
Correct.
But ultimately, my lord, the impugned annexure said, my lord, 9, your lordship may see, the writ petition has been filed challenging annexure 9. Lordship may kindly have a perusal. Exhaustive order we have passed in seriatim, taking into consideration the factual matrix.
What is that annexure 9?
That annexure 9 order has been challenged in the first writ application, that is 27/7/2022, where the court directed to consider the exhaustive representations which were to be filed, and we have considered the case that order of the Honorable Odisha Administrative Tribunal, where the claim of regularization was raised, and adjudicated. And now, Lordship may see kindly, even once raised.
Mr. Panda, every day we have been seeing these cases. Now, after Dharmapal, Jago, you have seen
we are conscious of that.
now.
And your Lordship,
I said one thing, the technical aspect, that is a technical aspect. Repeatedly, the same ground, same claim, same prayer being urged before the tribunal, before the Hon'Ble Court, and it was dealt with, it was complied with. We have filed compliance affidavit.
What is that compliance?
That compliance affidavit that
she cannot be regularized. Ultimately, what a daily wage or a temporary employee wants at the hands of this court? Status of regularization.
Even in the ban period, he was Uma Devi, that Uma Devi.
No, Uma Devi is half dead because of subsequent march of law. Uma Devi is not the final destination point.
No final.
There are many
but
Umas thereafter Devi.
Subsequent decisions never said that.
No, they have considered Uma Devi.
No, considered, but never reiterated that illegal appointment will be regularized. Only illegal.
Where is the illegal?
Because it was in the ban period.
Illegal
and temporary
What
appointment.
action you have taken? What action you have taken?
You continue the person to even retire.
Retire, and without taking any action, person who has done this illegality. To take action against those who have served the state.
More than 26 years.
How can that be?
Without any office order. That is our letter first.
That is
for daily wages, who will issue the order?
Yes, that is there.
No, you have increased the remuneration from time to time.
You have increased the remuneration. She went to the tribunal. Tribunal made an order. She went to single judge. Single judge made an order. And you have implemented the order partially. Yes. You never said that she is not working at all. Your case is working against the post. That is the reason why you have shifted particular post to accommodate her. Now Mr. Swain will stand corrected.
And there was a suppression of fact.
What is that?
That the previous order was not mentioned in the
everything is
WPC OSC number 44. Lordship, Honorable Court has passed that order. They have quoted that in page number, my lord.
Therefore, he is before the court.
Page number 7, running page 7. Running page 7 of the brief, order number.
No, Mr. See, some good case you fight, not against the tiny people. They are all poor people. They eke out their livelihood based upon sweeping.
We have to go by our records, my lord. We have to, my lord.
I appreciate. We appreciate too. We allow this nations.
Your Lordship, recent judgment.
We have said, we have one sentence.
Every day, your Lordship, in favor of
one sentence I have stolen.
In that case, engagement order was also not issued.
We have stolen one sentence from stolen. In fact, stolen in the sense I have put it. The illegality diminishes in degrees as the time steals away. I have made the statement in that judgment. Therefore, whatever point illegality, you can't say Alexander came here and that was illegal. He came and went back. You have to take it as a settled fact. We cannot go on chanting illegality, illegal entry like mantra. That will not help you. Because illegality, yes, it was illegal, arguably. When? As on 1396, because there was ban period. Ban period was for what period? Ban began when and when ended?
No, not ended.
Still it is banned.
Still,
but continuing. And you are continuing?
Because of Lordships are passing order.
You should have told that. No, you should have told that.
We are being injuncted. We cannot contempt the staring at others.
Naturally, you have to avoid
litigious employment.
No, not like that, Mr. Panda. I tell you. See, when they said pay the minimum wages.
Yes.
You should have said, no, he will not pay because he has appointed during the ban period. You accepted the order of the court.
Yes.
You have made the payment. And still you argue that no, entry is illegal. If entry is illegal, everything subsequently is illegal. That ground is not available to you now because you suffered 2 orders at the hands of the tribunal.
and we acceded to that.
Yes, so therefore, how can you argue like this now?
But my humble submission, one point only I raise. After we have complied with the order, regularization part.
So illegality goes now.
That should be full stop. He is again agitating the same issue.
No,
Yes, how-
my service has not yet been regularized.
And he has accepted that order, my lord, that tribunal's order.
No, I have not
Minimum
accepted.
wages.
I have challenged.
Like minimum wages is one thing. Status on regularization is another.
After we have complied with that order, he has accepted. Both the parties have accepted the order of the tribunal.
Accepted for what?
At the order of the tribunal, the man for minimum wages.
A minimum wage, but regularization?
Regularization that the tribunal.
That the complaint is now.
Tribunal did not accord that. He also did not agitate that.
Therefore, he is
agitated.
No, that order he is not challenging. He has not challenged that order, my lord.
Allowed in the light of Chago, the DB judgment.
I have given all the
One
judgments.
more judgment was
Sripal Dharam.
no, not that. We followed those two judgments and passed one order in the electricity matter.
Yes, I have given.
You that you only argued that matter
Yes,
along with others.
Orissa Water Supply and Sewerage Board versus
give that
Vijay Kumar. In my written note, I have given.
It is affirmed by the Supreme Court.
Yes, I have given.
The other day, that gentle lady told us that
Yes.
the SLP is rejected.
Yes, my lord, I have given in my written note.
You have given.
Yes, good.
But you have given some other judgment. Huh?
So, page 38. Sorry. And this judgment is of Karnataka High Court.
Not that. Here only. I am no longer from Karnataka now. I am your man. You should not treat me as an alien.
Yes.
That water
My
supply.
lord, kindly come to page 83.
Water supply and sewerage.
Water supply. Orissa Water Supply and Sewerage Board. I have given.
Hello.
But in the second writ petition, the order of the tribunal is to be quashed, and in the first writ petition, the order of the state government is to quash.
State government to be questioned. In the second WP, order of the tribunal to be questioned.
And despite
Earlier orders of the tribunal directing payment of minimum wages to be reverted to first off, contention as to the entry being illegal is to be rejected because of government continuing the petitioner and paying minimum wages in terms of wage illegality, arguable illegality. Subsequently, every point would diminish from year to year, and at a particular point, it may be it may completely evaporate. Like electricity board, what are the compliance division bench judgment? Performed in SLP number, do you have that?
SLP, I don't.
Kindly give SLP number. Yes, find out and give.
Yes.
SLP.
Dharam Singh Sripal, I have given.
No, that is referred to Jago's information.
And despite the interim order, they are not allowing me. You know, so may I kindly indicate that.
So what is the age of your client now?
He is 54.
Are you sure that
It was 54.
petitioner to continue in service, regularization to be. Yeah. Okay. We'll come back next. Yes.
Item 21. My lord, this is also agreed by the state.
Yes.
Where the state is aggrieved at the first instance that it was not any opportunity of hearing to file counter, and on the first date of hearing, the prayer made by the writ petitioner, the respondent number 1 was allowed, directing the state to regularize below.
Please repeat. Kindly repeat.
At 21.
Repeat. Kindly repeat.
My lord, on the first date of hearing of the writ petition, without issuing a notice to file counter, the Honorable Single Judge has disposed of the writ petition, directing the state to regularize the services of the writ petitioner. Therefore, my lord, we were not given an opportunity before.
Well, suppose if we give opportunity now, the effect in
the defect, my lord, we could have stated before the Honorable Single Judge.
No, we give you full opportunity.
Yes.
Because the apex court said, if the opportunity of hearing is given in the appellate stage,
that also suffices the natural.
It will suffice.
Yes, that I know.
Yeah.
But therefore specific, we have taken the contention that the petitioner, writ petitioner respondent number 1 was not engaged before the cutoff date. That is, my lord,
Uma Devi.
No. 1/2/1990. Uma Devi, we have followed Uma Devi, the dictates of the Uma Devi by our circular date 1997. We have stated that the persons who have engaged after 1993, considering their length of service 10 years, they have to be serially, they have to be regularized. And we have regularized many cases after following Uma Devi. But this solitary case we could not regularize because, my lord, 1/2/1995, the cutoff date is 12/4/1993. The ban was imposed, and we have annexed that document, Dossimetry Annexure 1, page 16, that Department Circular imposing the running page 16 of the appeal memo, imposing ban on recruitment of work charge employed in NMRs and a ban on engagement of persons on daily wage personal responsibility on person engaging and disbursing wage of such persons. We have imposed
Where is the government order?
Government order of what?
Banning.
Rejecting.
Yeah. Banning recruitment.
That Annexure 1 at page 16, my lord.
This is a letter.
Circular. That, my lord, that Gazette notification. This is Finance Department, my lord, circular.
Kindly see the wording of Article 162 of the Constitution. This is a letter. We don't say it's a hate letter or affectionate letter, etc. A letter is not the policy statement of the government. Government should evolve policy. Policy has to have a particular attire, a particular dress. All will have the attire.
Grateful,
because it's a government.
Bow down, my lordship. But the letter is in reference to the, my lord, I am directed to say that the Finance Department in the letter number so and so dated November 1973 had conveyed that further recruitment to the work charge establishment shall be stopped with effect from the date of issue of the order. So, my lord,
these are only letters and therefore nobody has followed. It should be government order. Where is the government order which stipulates the policy?
See then the Gazette notification. The Gazette, the next page 17. The Gazette notification May 30, my lord, 1997. Resolution dated 15th May 1997 has been notified in the Gazette. It has been brought scheme for absorption of NMR DLRs, job contract workers under regular establishment.
Those were appointed after the ban also?
No. After the ban.
Then where do you stand?
Before the ban, they cannot be.
Those who have been appointed post-ban period,
my lord,
are also within the sweep of this resolution.
Yes.
Then how can you say ban is an absolute bar?
The authority competent also, my lord, the regulation shall.
the resolution,
my lord,
which arguably is issued in exercise of executive power.
my lord.
That resolution ought to have excluded those who gained entry post-ban. If entry is banned, then you should not have given the benefit under this resolution.
My lord, post-ban, no, Lordship, see, ban was imposed on 1 to 19, that where Lordship is not accepting.
No, clause 2 mentions of the ban also in the resolution.
Clause 2.
Prior to ban. Engaged prior to ban.
Prior to, yes. The workers should have been engaged prior to 12/4/1993. At para number 1993. Para 2.
No, you take it in 11 also. The authority competent who shall issue the order of regulation shall certify that the person who are being regulated in the order were engaged prior to 12th April 1993. That is prior to promulgation of ban issued by the Finance Department.
Yes. That was saying so.
Kindly come to paragraph 5.
Paragraph 5. Absorption against the post for which regular recruitment rules have been framed will be made in relaxation of the relevant provisions by the competent authority. The paragraph 11 may kindly be seen.
The authority competent.
My lord, who shall issue the order shall certify that the person who are being regularized in this order were engaged as prior to 12th April 1993, prior to promulgation of ban issued by the Finance Department, and it has been agreed. My lord, this reject notification has never been challenged by any writ petition, and it still is enforceable.
Yes.
Only one submission, Lordship. Your Lordship may kindly turn to Annexure 3, page number 19. It's a case of 29 years of continuous service made against a sanctioned post. And the resolution that my learned senior is relying upon is not applicable to the said petitioner in the said department, because Annexure 3 at page number 19, it's a separate resolution which is applicable
to your case.
To my case.
Page number?
Page number 19, Annexure 3. This is a separate resolution which is applicable to the person working in H&UD department, under which the petitioner is continuing, which says, yes, the cut-off date is 19/5/97. 97. I mean, I'm working for 1995. Therefore, it says after the cut-off date, those who are working, they will be disengaged. And before the cut-off date, those who are working is to be regularized after completion of 10 years.
Welcome this letter, Mr. Pandal.
Mr. Panda, come to Annexure 3 letter.
Yes.
And the regulation of service in non-LFS cadre may be considered by the respective councils, befitting to their qualification in respective posts as well as completion of on completion of 10 years service as tailor and nurse against sanctioned post.
Not only that, kindly come to. I am directed to invite reference to the subject and say that so and so maybe this again forthwith. So if not yet done.
So far as
further
date, we not the 97 date, 19/5/97. He is appointed 95. Therefore, he is saying that it is applicable to him. Yes. But it was not made in against any sanctioned post.
No, DLR. Can you argue for continuing a person beyond 2 decades? Still, can you say he is continuing against non-post? We have rejected that contention in your own matter. It is submission. You had appeared in the matter. We have said we reject Panda's argument.
But lordships can change your lordship's
No, how
mind.
can we change? We are not chameleon.
No, not chameleon. I'm saying that the appreciation of facts and when it came to the light, new arguments are advanced, my lord.
No, where is the point?
The point, my lord, that it was, and there is a lordship, there is a restriction in section 73 of the Orissa Municipal Act. No appointment can be made beyond 6 months with the state government. That is also
correct. What action you have taken against those who made it?
Because, my lord, we have not taken any action.
Then you allowed tacitly. It was not known to you. In Orissa, many people are, there is no regular recruitment at all, barring one or some few exceptions.
Now it has been deprecated by the Supreme Court, and we have abolished all contractual rules.
Now, see, you have allowed those people to work. You have sucked their blood, perspiration, etc. And now saying, no, Orissa Act says nobody should be appointed that way. Very well. But where did you follow that act? And what action you have taken against those who violated the provisions of act? You cannot be sectarian in victimizing the people. You should have taken action against those people. See, you have violated law. You have made appointments. For what purpose, we do not know. Maybe you have pocketed few pennies also by giving an engagement. Therefore, you are liable to be punished. There is one such case. You cannot be sectarian in that. Who planted the poisonous tree?
They will be rewarded. They will be
rewarded.
And they will be allowed to go scot-free.
The fruits of the poisonous tree, they are being targeted.
And for their laxity, these things are happening.
Yes. What to be
grateful. But so far as this gadget notification and the subsequent resolution.
We'll treat them also.
Yeah.
I'll say that. Right. Which is the serial number?
21.
21.
Well, I have also filed an objection. I have meticulously dealt with each and every argument they have at objection, my lord.
State is in appeal, in the intra-court appeal for laying a challenge to a learned single judge's order dated to the date
23/4/2024,
whereby respondents WPC number 9708 of 2024 having been favored, the following relief has been accorded to him. Please by the pattern, paragraph. Next paragraph. Learned AGA Mr. Panda, in his usual vehemence, argues that the impugned order has been made without giving due opportunity to the appellant, and therefore the same is grossly in violation of principles of natural justice, and as a consequence is liable to be void. He draws our attention to 12/4/1993 Gazette notification.
That is not a gazette. That's a letter of the Secretary to Government Finance Department.
Of Secretary to the Department of Finance, to all secretaries of the department, to the effect that no person shall be engaged after 12/4/1993 And therefore, the engagement of services of the respondent itself is illegal. First of all, that being the position, no relief could have been granted to the respondent by the alleged single judge. First, he also drew our attention to the resolution dated 15/5/1990.
Published in Orissa Gazette.
Duly published in State Gazette, to the effect that those who have been engaged post-ban period should not be granted benefit under the state resolution. First one. So, arguing, he seeks widening of the impugned order. First, kindly be seated. Learned counsel representing the respondent employee, per contra, resists the appeal, making submission in justification of the impugned order and the reasons on which it has been considered. First, he draws attention of the court to which is that, brother?
Page number 19, annexure 3.
Letter. The letter dated 15/12/2000 issued by
the Director of Municipal
Administration to the executive officers of all urban local bodies and says that the ban order or the resolution which Mr. Panda pressed into would not be applicable to the case of his client. First one, he also cites Jago, Hon'Ble, etc. And also a DP judgment of this case in Orissa, sewerage board, etc. Sewerage board. Next, having heard learned counsel for the case and having perused the appeal papers, we decline indulgence in the matter for the following reasons. One, the vehement submission of they entered the impugned order without giving opportunity of hearing may not be much treated in as much as we have given full hearing at the appellate stage. First time. Want to say anything?
Yes, but only one submission, Lordship. Your Lordship may kindly turn to page number 21. Opportunity was given, Your Lordship may kindly see. Only one submission. Page number 21. Opposite me, Your Lordship may represented by so-and-so versus so-and-so, represented by Mr. D. Naik. But he is the counsel who usually...
He says, at the admission stage it has happened.
Yes.
And at least we should have been given a reasonable amount. Therefore, we told them. Apex court in so and so has observed that the lacuna of depriving a person of opportunity of hearing at the initial stage at times can be cured by giving full opportunity at the appellate stage. This is a facet of doctrine of post-decisional hearing. First up. Next point. The second contention of Mr. Panda that there was a complete embargo against engagement otherwise than regular recruitment with effect from 12/4/93.
Yes.
12/4/93. And therefore, any entry post-ban is illegal. Come on. is difficult to countenance. First, reasons for this are not far to see. Well, firstly, ban of the kind cannot be treated as a China wall, impregnable China wall. Secondly, even after the ban, thousands of employees were engaged, maybe in violation thereof, and state cannot argue that it did not know about that. First off, thousands of cases, in thousands of cases, this court and also the apex court have noticed this and granted regularization in worthy matters, notwithstanding ban of the kind. Thirdly, no action is taken against the officials who trampled the ban and made these engagements. First, if ban were to be very serious, the state would not have ignored its violation. First, fifthly, whatever arguable illegality, would diminish year by year and should vanish at a long point of time, as has happened in this case. First, next point. Learned counsel appearing for the respondent employee is more than justified in drawing attention to DME's letter dated 15/12/2000, which reads as.
My lord, I also rely upon the same, my lord. For that only, if there is no sanction put available now, how can he be regularized? If he is not working in a sanction post, how can we?
Can you read Jago last paragraph? Can you give Jago, please? Give that judgment.
That is already answered. That is how the position is.
Apex court said that argument is not available to us after decades having passed.
Then supernumerary post will be created.
We do not know.
Thanks.
We do not know what all you should do to comply with the court order. These are the matters left to those who suffer the orders. In fact, this contention is considered in two judgments. They say such a contention is not available.
The part of record, my lord, which says sanction vacant post is there. Who sanction post will attached?
This conundrum is there, but in
the sanction post is also there.
Yes. There. Well, that is there in my writ petition also.
In the writ petition itself.
Yes.
We are not the now. Whatever material in the writ appeal, I am to place a lot.
That is.
We are never
whatever. Mr. Panda interjects at this stage to tell us that in the absence of sanctioned posts, the letter of DME will not come to the rescue of the respondent. First, we do not agree with this because the commissioner's letter dated 31/1/2024 issued by the Commissioner of Cuttack Municipal Corporation, a copy whereof was already and was Annexer 8 in the WP, gives an indelible impression that there existed two posts. How many posts, brother?
But there are two posts. Both the persons are working in the vacant post. It's a case of direct and direct post is vacant.
Or there are two posts. And that the respondent is working. How many respondents?
Only one respondent.
Respondent is working against one of them.
Yes.
Yes. No, very clear. It is part of the appeal memo. It was part of writ petition.
Writ petition.
Writ petition also. First. The case of the last one, learned counsel appearing for the respondent is more than justified in placing reliance on the march of law from Uma Devi to Jago. And to an extent, the ratio in the former being diluted. First, in the above circumstances, the petition being divided, or writ appeal being devoid of merits, is liable to be dismissed, and accordingly it is. Courts having been made easy, very reluctantly made easy. First off, the order of the impugned order of the learned judge, single judge, shall be implemented within 2 weeks without giving scope for punitive action in contempt jurisdiction.
Within 4 weeks.
6 weeks.
6 weeks.
6 weeks.
Great.
Next. Item 22. But we appreciate government lawyers, I tell you, the way vociferously you argue. That is the way you are expected to argue.
Grateful, Your Lord.
Not just nodding head.
We may not be
Judges will say.
now.
No, you are doing your job. Yes.
Yes. 22.
My lords, the impugned order is at page 12.
Impugned order at page 12.
My lords. On the first date, the order was quashed under the Annexure 11.
What was that order?
That order was, there was a direction from this Honorable Court to consider the representation of the petitioner.
How many years of service?
My lords, here he was getting regular pay.
Grade pay.
Now he claims RSCP.
My lords, the first line, Your Lordship may see, in view of the order dated 30th 3/2022. That is in the judgment, Your Lordship may see that.
1 second, let him complete. Then we'll come back to you. Kindly be seated. Yes, sir. Your first contention is, Mr. Behra?
My lords, opportunity of hearing or controverting the pleadings in the petition was not afforded, my lords.
All right, we will give you opportunity now.
My lords, in writ appeal, we have specifically stated that this case is not similar to Bihari Lal Barik.
WPC 8226 of 2021.
My lord.
Annexure 13.
My lord. 13 is similar, but it is not, it is Akshay Kumar Mahanti. Basing on that, Bihari Lal. Yes.
How it is different from this case? Kindly demonstrate.
My lords, in para E at page 8, though it has not been specifically pointed out, the averment is that the case of Bihari Lal Barik is completely different from the case of...
Yes, show that now. Let us go to that case.
My lords, that writ petition, the connected writ petition arising out of this the appeal is filed in para at page 40 by order dated 9/2021.
Page 40?
48.
The authority to work out the direction of the Honorable Court issued in the division by taking all effective steps within a period of 1.5 months from the date of communication of a copy of this order by the petitioner. Failure in compliance will be construed to be an elaborate violation of the court of considering the limitedness that was consider the representation.
My lord, the order which was quashed
in that order, it was explained, whereas the Ramchandra Jhankar petitioner in the writ petition was initially appointed as Jamin on 22/1/2079 on ad hoc basis with scale pay of 240 to 315 per month. He was allowed scale pay of 5,200 to 20,200, the grade of 1900 with effect from 1/1/2006, and third RSAP with effect from 1/1/2013. The scale pay of 5,200 to 20,200 with grade pay of 2,200. He retired from service on attaining the superannuation in 34/2019. Though he was an ad hoc employee, still he received his salary and other allowances as a government employee till the date of his retirement in service has not been regulated. There is no rule doing promotional hierarchy to the post of revenue inspector. He claims that he should get this scale, revenue inspector and revenue supervisor. As such cadre rules have not been framed under the water resources this department in respect of the post of admin. Since there is no promotional hierarchy for the post of admin in CAT organization, the post of admin
From you are in what category?
My lord, I am Amin, your lordship.
I mean, is there any promotional post?
My lord, Amin, then revenue inspector, then revenue supervisor.
Then how you are going to get the RACP?
My lord, since we are not given that promotion, my lord, only your lordship may see Annex 12 of writ petition, page 51. 20 approach before to the honorable single judge, and the judgment was passed. In all cases, the rejection order was there, and by quashing the honorable single judge has remitted matter. And in page 59, the government has extended all the benefits to the 19 persons. The only person was left. Page 59.
Who are on par with you?
Yes. We are previously 28 approach before the honorable. Basing on the page 59 for a moment, your lordship may see. Page 59.
In mine.
My lord.
List. Order dated.
Petition, page 59. The 51 judgment was implemented in case of all these employees. And in my cases, when I have approached after 6 months, and by quashing that this is the second round, and they have extended all the benefits to the others, my batchmates.
What do you say?
My lords, before
how they
2013, SCP was applicable, my lords. So, advanced career progress. So, if somebody has availed that SCP is not entitled to SCP.
But RACP is given to rest of the people.
Given to him also, my lords. One
to you.
Yes,
my lord. My brother is. I have been extended the lower RACP benefit, and that
others have been given higher RACP benefit.
That was clarified, and a lengthy judgment was passed by quashing the rejection order. Thereafter, the government extended benefits to all.
Which is that the quashment order is dated?
Page 51. Dated 3/3/2030.
No, I must. We are asking one question.
58, my lord.
Persons who are similarly circumstanced for the respondent, have they been granted RACP benefit of higher grade or not?
My lords,
you cannot create a clause within the clause. That is Article 14.
My lords, what I only submit was not been adjudicated, had to be given.
No, there should be one more adjudication. How many people should come to the court? One will do. If one comes here and gets the relief, all other persons similarly circumstanced need not come to court. Krishnamurti judgment. Krishnamurti says, you cannot drive all people to the court. The court are flooded now. They are flooded because you send all individual cases to the courts.
My lords, what I submit, my lords, in ground number E, it is generally stated that this case is not at par with that judgment under Annexure 13, 12, my lord.
Yes.
So let them specifically say how it is different otherwise.
No, all right, we will accept your first statement. What about the contention of your friend?
My lord,
How many people are there totally?
My lord, totally 20.
20.
20. And they have been initially approached before the honorable single judge.
All right, we'll come to that one now. You have said it thrice now.
Man.
Out of 20, you are one of them. Out of the 20.
My lord.
You are one of them.
My lord.
You were also before the court earlier.
My lord.
And of them to 19 they have given now.
They have given, at that time my case was not listed. My lord,
Because to 19 it has been given.
My lord.
Benefit is given.
My lord. By
then how can you say we will not give benefit? It will come after that. Just look it.
Man.
In this matter, my lord has disposed of the writ petition, had ordered dated 8th January 2026.
But date is mentioned as what?
My lord, here, my lord.
8/1/26.
My lord, what happened, my lord? He has, the opposite party number 1 had filed an essay that 132/2024. That withdrawal of that essay has been omitted in the Lordship's order. For the amenable of the interpretation of the Lordship's order, that is what, because given a chance to raise his grievances in essay, which is filed by his brother 71/2017 in the self same.
He will implead in 71.
Yes.
And the one which is initiated.
That will not be continued, withdrawn.
That what is the number?
That is 132 essay number 132/2024.
132.
We have indicated.
132. 132 of
2024.
24. Essay. Filed by
opposite party number 1.
Then that can be disposed of.
Yes, may I submit my as per my lord, my lord's friend consent of the parties, your lordship dispose of the writ petition directing to implement the party in the 71.
But you can't pursue that remedy. That you have to stop that remedy.
No, what I am telling you, lordship, I am not going. Your lordship has permitted to file an application before the DRT to implement the party in 71. And that will be done within 4 weeks. The 71 has been posted to 6 February. And 132 has been posted to 24.
You undertake to withdraw that?
I will withdraw that. Because my learned friend is so anxious, over anxious to that effect. That is only one requesting one.
They gave an opportunity to you to come and appear, and they gave opportunity to sit with brother.
Only one.
When the date is fixed?
My lord, one request.
When is the next date?
Next date is 20th February.
20th February.
20. I have ascertained all these things before the tribunal.
Okay.
One request to us. Only one line of the present applicant may be permitted to file its pleadings.
I had come under
on his application.
Yes, that is the crux of this.
No, my lord. My application, my lord, since my lord has concerned the parties that taken the lenient view, your lordship must permit me at least unless I will be prejudiced.
Obviously.
That is actually question.
Right. Mr. Mohanty, Learned Counsel appearing for opposite party number 1 submits that the essay number 132 of 2024 initiated at the instance of his client shall be withdrawn by his client when the matter is taken up on 20th of February 2026. In view of the said statement, the application moved by the petitioner starts disposed of. Mr. Mohanty, since this court is allowed him to get allowed the opposite party number 1 to get included in essay number 71 of 2017, he may also be permitted to have his own pleadings. Since we have by the order treated so and so, we allowed the opposite party number 1 to get himself included in essay number 71 of 2017. Needless to say that he can file his own pleading, and the opposite and the petitioner and all necessary party in the essay 71 of 27 shall also get opportunity to respond to the pleading to be filed by opposite party.
Opposite party bank, you also mentioned IPO bank. Okay.
All of you respond to that. In view of we
The post we are there. Not if that, not week after, and it can be taken up next week.
Next week?
Yes, but the reason being it's a
So next week, we are not sure because calendar is full on.
A week after
next week. Week after next week? Yes. Yes.
The reason being, it's a Sarpanch disqualification matter. It is going to be over. So, not up to your lordship.
Well, next week you put it, let us see. If it does not reach, then we can put it.
Your lordship, in this week.
Yes. On the revisions. Yes.
Item 22.
Yes, 22, Mr. Brother.
Item 22?
My lord, sir, I am here.
How it
it is similar to.
Similar. Yes. Take on. Knew that judgment. This intra-court appeal by the state and its officials seeks to call in question a learned single judge's order dated 2/1/2024, whereby respondents WPC number 41924 of 2023 having been favored, the following relief has been granted. Paragraph.
There is a delay of 179 days.
Yes, my lord. Paragraph 2. Paragraph 2. Just 2. Next paragraph. Learned State Counsel Mr. Behura very vehemently submit that the learned judge, single judge is not justified in disposing of the appeal at the admission stage without giving a reasonable opportunity of meeting the contentions of respondent in the writ petition. He also submits that the decision in WPC number 8826 of 2021 disposed of on 30/3/2022 could not have been banked upon by the learned single judge because of factual difference in the cases. First of all, so arguing, he seeks following of the appeal and voiding of the impugned order. Next paragraph. Learned for the respondent employee stoutly resists the appeal, contending that the learned single judge is more than justified in relying upon the decision in WPC number 8826 of 2021, there being absolutely no difference between the facts of that case and the facts of his client's case. Semicolon. He also submits that if merely because no opportunity was given, arguably, to the appellant's hearing, they can put forth their grounds before this honorable court, and therefore remand is not to be resorted to. First off. Next paragraph. Having heard learned counsel for last one more point, he hastens to add that as many as how many people persons have been given that benefit?
Annexure 13, 19 persons.
As many 19 other employees similarly circumstanced with his client have been already accorded the RACP benefit by the government order dated the 13/6/2023, a copy whereof avails at Annex 13 to the WP. Well, first. Next paragraph. Having heard learned counsel for the party and having perused the appeal papers, we are of the considered view that learned single judge has rightly followed the decision in WP so and so. There being between the facts of that writ petition and the facts of case of the respondent. And as many as 19 officials have been granted RACP benefit, while the office order number 1338 dated 13/6/2023, a copy of which was readily available to the learned single judge in the writ petition at Annexure 13. First up, denying relief to the respondent would have caused violence to the principle of equality enshrined in Article 14 of the Constitution of India. First up, despite vehement submissions, of Mr. Behural, we do not find any significant difference between the facts of the case in WPC, which is that
WPC 8826. That was the first one of Annexure 13
of 2022, and this case, end of this case. First one, in the above circumstances, there is no merit in the appeal, and therefore the same is dismissed.
Delay 179.
Order of the learned single, impugned order of the learned single judge shall be implemented within
2 months.
8 weeks. 8 weeks. Without giving scope for punitive action. Punitive action under the contempt law.
Second contempt is now going on.
But now we have this. Perhaps they wanted time for implementing the order, therefore they have filed the
on the ground that appeal is pending. I know.
Yes.
Item 23 has been adjourned. Item 24.
24.
Item 24.
24.
Yes, sir.
Here the appeal by the state my lords. My lords, the facts of the case is like this. The petitioner.
1 second. State cannot create a clause within the clause, there being no objects or achieved in connection with the differential, founded on differential. Okay, that in that one. Yes.
My lords, the respondent retired from.
Where is your friend? You are here. Okay.
Retired from service from 1/6/2002.
1/6/2002. What was he?
He was clerk. My lords, matter relates to imposition of penal rent because he overstayed.
Penalty, disciplinary proceeding.
No, my lords.
Some quarter.
Oh yes, quarter.
Overstaying in the quarters.
Retaining the
Penal
quarter
rent from the
yes, penal.
How many days he overstayed?
Overstayed up to 7/4/2006. Because he approached this honorable court and honorable court directed him to vacate, give time when he will vacate. He vacated on 7/4/2006.
Yes.
From 1/6/2002 to 1/4/2006, he has to pay at the rate
penal rate. Which is that rule?
107 of service.
7A.
Rule 107.
7A of the service.
That comes to 1,34,947.
What the learned single judge says?
Single judge observed that you have not asked him to vacate there was no cancellation. That
he is bound to vacate. Yield the quarters to others. There is one judgment of the apex court, which is that overstaying in the official quarters. Supreme Court deprecated in one matter, it levied cost of rupees 1 lakh or 2 lakhs, I remember. What is the reasoning of the learned single judge?
That is that he was not, the quarter was not cancelled. That is why he is not like.
Notice was issued to him. Not okay. Why there should be notice? Can kindly come to para 6. We don't agree with that.
Supreme Court decision has referred in the Odisha case, matter was carried to Supreme Court. In that case, Supreme Court held, unless you declare unauthorized, you cannot levy the penalty.
No.
That has been referred.
Give that.
That is page 3 of the judgment, single judge.
Official quarters are meant for officials.
They have accommodated 2 others.
Let it be. What is
same
your
ground.
right to stay on that?
My lord,
What is your right to stay on that?
my lord, I have been the High Court. High Court directed to vacate. I vacated, thereafter I vacated.
But why you did not vacate on the day of return within 30 days perhaps? Within 30 days.
Maximum 4 months.
Maximum 4 months. 4 months will be over on 1/6 to 39.
But the Lordship say the single girl price.
Heavy cost on this. We are living heavy cost of 1 lakh rupees.
No, that is based upon the Supreme Court decision.
Yes, very well. I'll consider. We'll consider. Give that.
Lordship, see the findings.
Yes.
There are 4.4.
No, what is your right to stay on the official quarters? You say
I have
official.
On health claim, I have prayed. They have accommodated.
Where is that accommodation?
Well, that is
where is that letter that you are permitted to stay in the official quarters for 10 years?
No, not 10 years. Not 10 years, man.
6 years.
No.
2002 to 2006. What is your right to stay? Tomorrow nobody will be getting the quarters at all. Will impose having.
I have bought my health ground in similar 2 cases they have considered. So I prayed them to retain the quarters. They have allowed me to retain the quarter. Then I approached the High Court. Then High Court directed you vacate. I vacate. Thereafter in 2006 I have vacated. Court has stated from date of declaration unauthorized from 2000 to 2006 I will pay the penal rate. The rest of that I will pay standard rate. That is the view of the court.
The terminal benefits are settled now.
No, my lord.
Not settled. Then good thing. Yes.
That period court has you pay standard market rate.
No, we don't agree with that.
From date of
directive this cost. It should be a message to all employees. 1 lakh rupees cost.
But the old man.
It should be very old.
My lord, this is based on the Supreme Court decision. On same point, my lord, lot of cases were decided.
All right, we will take a different. Official quarters are meant for officials. After retirement, if I retain this quarter,
in the exception,
judges do.
Supreme Court decision they have quoted.
Give that.
Well,
give that.
In the judgment itself, that.
Yeah.
4.4, my lord. The tribunal filed order dated 2010 directed opposite to take decision petitioner claim. It is contended without proper application of petitioner claim made before the tribunal. Opposite party have passed input order by upholding demand raised against the petitioner towards penal rate. Tribunal has directed. Earlier I have gone to tribunal.
Yes.
Tribunal directed you consider. It is contended that though on his retirement of 2002, petitioner quarter, but no point of time was issued any notice directing to vacate the quarter till notice was issued by the state officer in 27/12/2005. It is contended that the petitioner when challenged with notice before the 2000 WPC number 2006, the court permitted the petitioner to vacate the quarter within 7 days. Thereafter I vacated. And earlier tribunal has directed to consider the health ground and other grounds, directed the consideration. They have not considered that. That was kept pending. Then let's come to Orissa decision. This court has referred. Petitioner is not liable to pay any penal rate. In that decision I have referred. In question therefore whether tribunal is view is correct in law, it is seen under rule 104 of the government rules reserve its power to regulate the allotment of houses subject to term of the conditions as it may be regulated under the instruction issued furtherance thereof. The rule 11 deal with the allotment of houses officer owned by the government or leased by the government. As the case may be, rule 2(1) provides that general special order for fixing fees excess of what prescribed clause B referred to the clause 6 provides that where government servant does not vacate the residence after cancellation of allotment, that is the rule, my lord. Yes. The government is empowered to collect the rent. Rule 104, my lord. The further the procedure has been laid down in the proceeding of the government letter dated December 2086. Therein clause number 2 adumbrates that government servant who cannot vacate the quarter for genuine reason, I have given the genuine of health and other absolutely compelling reasons,
I have held and other compelling reasons.
What is that other compelling reason?
I have given judgment. I will come, my lord. The tribunal has directed. You consider him. You have considered two cases. Thereafter, I came to the then vacate the quarter for genuine reasons, health and other absolutely compelling reasons, further for a period of 1 month only, within prior written permission of the director state. On the advance payment of the standard rate. I am paying standard rate.
No, may retain the quarter only for the period of 1 month only. So prior written permission of director.
In other words, government servant after retirement transfer is required to vacate quarter except for genuine reasons. With prior written permission of the director state, he shall not be entitled to retain the quarter only for a period of 1 month on paying advance standard rent. Those 5 advises that government servant after retirement may be allowed to retain the quarter occupied by the maximum period of 4 months. Provided rule 4, advance payment of normal rent 4 months. But DCRG will be released only after the vacate the quarter rent at the rate of 5 times standard rent will be charged for the period of occupation of the quarter beyond 4 months. The 5 times minus. In regard to appeal arising out of SLP number certain filed against the order of the tribunal, OA number certain 93, the admitted position that a respondent was staying in a government quarter in current year, it is seen that above regulation referred earlier relates to quarter allotted to the government service. Under the circumstances, the levy prescribed by special order of payment of penal rate is in excess of prescribed limit occupied owned by the government at Cuttack and Bhubaneswar. The government thereby denied itself any power to charge penal rent to the building occupied by the government in other places unless rules and general direction is issued. The tribunal therefore was right in respect of that case only, but in all other cases, the order passed by the competent authority has become final. Government is devoid of power to levy penal rent for the overstay. Even in respect of other cases where the government servant overstay beyond period of permitted by the High Court.
Yes, read.
The government servant are required to pay penal rent beyond the period permitted by the order passed by the competent authority or by the High Court. In my case, High Court in 2006 director vacated immediately. So court has consciously held from 2000 to 6 till vacation penal rate. Prior period they will standard rate. They will standard rate means market rate. They will relate.
Then you read, sir.
Well, as the case they are required to consider each case only on exceptional circumstances for giving direction to
permit a government servant beyond reasonable period. Exceptional, sir.
But the object is to enable the government servant on transport or voting allotment entitled to be provided on accommodation. Making all these submissions and counsel appearing for the petitioner contend that the impugned order is not certainly IF law, petitioner is not liable to penal rate as assessed. Then government submission. The S.S.MISHRA additional government on the other hand contended that since petitioner was in retirement 2000 never vacated the quarter, he was issued with 27/12/2005 directing to vacate the quarter by 21/2006. It is contended by the petitioner remain unauthorized occupation of the quarter with effect from 1/3/2002-2006. He is liable to, that is submission of the government council. The learned counsel for the state contended since petitioner was held liable to pay did not pay the same, his gratuity amount has been withheld in terms of the provision of the Rule 68 of the Orissa Pension Rule. Accordingly contended that opposite partner has not committed any irregularity in rejecting the petitioner claim impugned in answer 5. The petitioner is liable to be done. Having had the learned counsel for the parties, after going through the materials available records, the petitioner while occupation of the quarter E by 83 Jobra Colony, Cuttack is retired from on attaining age of superannuation of 28/2/2002. It is that record that the petitioner remained unauthorized occupation of quarter after but no notice was ever issued by him directing to him to vacate the quarter till notice.
That is what put to you, sir. That is what put to you. Is there any rule to issue a notice, or you have to go for advance permission? To go for permission in advance on premise of standard.
I have sought for permission, tribunal directed.
Have you got the permission to
sought for permission. Court has directed you to consider that. I have not considered. That is a judicial order.
So there is a deemed permission.
No. I have sought for a permission. I went to the court. Court directed to consider. They have not considered. That record I will bring, madam. That is court has discussed. Quarter till notice first time issued by the ADM from state officer or Kotak on 27/12/2000. It is also found that petitioner challenged the notice in WPC number such and such in the court by order dated 31/3/2010 allowed to 7 days time to vacate quarter. It is found that petitioner vacated his quarter on 7/4/2006. Because I went to tribunal, then I come to High Court. Then they raised
quarters is what these official quarters are not meant for squatting by the retired employees.
No, in exceptional case.
You have considered? Take down. 1 lakh rupees cost we are levying now.
I will file objection. This is
what objection?
I will file objection to the
in appeal.
I will get ready, my lord.
No, you have argued already.
My lord, your lordship,
no,
you must give one chance, my lord.
No, given. You have
argued the point of law.
You have argued. What we are deciding that.
No, it's one chance I will get ready.
I think we should give. You have already argued the matter.
No, I will speak. No, old man, lordship, give me one chance, my lord. I am giving you folded hand. Lordship, pass that order.
You have already argued the matter.
I will get ready with all rules and judgment, my lord.
You have argued, you cannot say all.
No, one chance I have folded hand, my lord.
No.
My lordship, give me one chance, my lord.
Rupees 1 lakh.
One chance, my lord. Old man, he is dying.
The old does not make law does not make any difference between.
My lord, I am saying no, my lord. My lord, imagine.
No, kindly do not raise it.
Imagine.
You have been heard in the matter.
My lord,
you have been heard in the matter.
My lord,
raise your voice.
I will play some rules, my lord.
No, don't express that way. You have been heard. Don't that way. We are warning you. You have been heard in the matter. And after having argued the matter, you want to raise the voice.
It's the rules, man.
Let us alone.
Cost will be in the deathbed. He is suffering from cancer.
What we can do?
My lord, he is not at fault, my lord. My lord, one second, my lord.
You can go on arguing the matter.
I will arguing, my lord. I will only place the I will place only the record. The court has a tribunal has directed.
You have argued.
You have argued. High Court has directed to vacate.
How many times you say that?
Only on that point I will.
We have argued already.
I will come with the rules, my lord.
No,
service code, my lord.
Yes, next.
Call
next.
My lord,
call next
Item
matter.
27.
Don't waste time.
My lord, one chance,
no chance. Next.
Item 27.
25, 27.
Considering cost, my lord, you may allow the. My lord, in the suffering,
you have now cost will be increased because you are wasting the public time of the court. You have been heard in the matter. You are given full opportunity. And still you want time in the matter?
I only said the lordship pass the order. Cost of them.
No. That is cost. Yes. A message should go to all retired employees that they are not supposed to retain the. Suppose if a judge, as a judge, if I must retire, if I retain the official quarters, what the other judges should do?
This case will manage.
You have argued.
He is in deathbed, my lord.
Next, let him. Let him live long in his own house, not the official quarters.
In the deathbed, my lord.
Next.
That.
Next. Call the next matter.
Humanitarian ground, my lord.
Call the next matter.
Item 27.
May I please, your lordship? Case relates to regularization of watchman cum sweeper. He has already rendered 26 years of service. Not a single judge, your lordship, dismissed my case.
Leave that rule book with me. Your rule book.
Man, yes. It is under the service code 107A.
Give that. Yes. we will make it a reportable judgment. The message should go very hard to the all retiring employees. Otherwise, this problem will arise. All scatters. Yes. Yes, sir. Their appeal. Your appeal or their appeal?
No, my
yes.
I lost before the learned single judge. My case relates to regularization. I am watchman come sweeper, Your Lordship. Claim what is the reason of rejection, Your Lordship? That is, there is no sanction post, recruitment procedure has not been followed. That is,
how many years of service?
25 years of service, Your Lordship. From 2 to 2026 till date, my Lord.
Which month? Which day?
My Lord, that is date, Your Lordship. That is Annex 1.
14/12/2000.
15/12/2000.
Contingency at the rate of 40 rupees.
15/12/2002.
No, 2000.
2000.
2000, my Lord.
As daily wage.
Months.
Yes, ma'am.
Rupees 40 per day.
Daily wages. 40 rupees per day.
Thereafter, it was increased from time to time. That is all the annex. Now, Your Lordship, I draw Your Lordship's attention to the impugned order. That is straight to that Annexure 6, page 88. That is the relevant portion. I want to waste Your Lordship's valuable time.
Para 9.
My Lord, para 11, Your Lordship.
Para 10.
10.
Para 11 is the operative portion. Applying with the Lordship's permission.
10.
That the status of permanency cannot be granted by association such association will yield the functions and powers with regard to not be aggravated by the court. Applying the principles of permanent
This is decided when? Before Jago?
Before Jago.
Much before.
Much before Jago.
Jago, Your Lordship. And
because it was in 29.
Let me complete. That is your mind.
10/24.
Minus.
Jago came on?
Jago came on sometimes in 2005. October, November.
November 24. 1 month after this.
Yes.
Yes, brother, we are allowing the appeal. Unless he disturbs us.
So that is my employer has also admitted that it is our irregular appointment.
Kind of advocacy we do not know.
Millard, sorry from the bar because of the
for advocacy.
Well, sorry, my Lord, extremely sorry, Your Lordship.
You may not take it. Otherwise, from the bar sometimes over anxiety it comes up.
We are telling we want to
sometimes because of the anxiety, old man, 80 years, that may be considered.
Who is 80 years?
No, that old man, I am not.
No. He was 63 years. Not 80 years.
The previous matter? No, as it has been mentioned, we have.
In this matter, 59. This matter, 59.
No, not yours. Mr. Manthi is referring to the earlier one.
My Lord, earlier one. Right?
No, I am not talking about the
That's why anxiety has to come.
In fact, what we were taught is, unless the judge says something against you, you are not supposed to stand up also. Because the judge, how many cases we decide? Thousands of cases we decide.
Yes.
How much material we have? We can scan all that within seconds. In this
different categories.
Uma Devi, then Kailash, then which is that Kesari, all that will be reflected within seconds in the mind of judges. Then we arrive at a particular point. We have been taught in the law school and in the bar also. When judges are not asking any questions to you, don't go and touch the ghost.
How to start and where to stop.
We are ghosts actually. When we are in your favor. In 9 months before the memory fades, He writes, the great art of advocacy is to know where to stop our argument. He writes that.
How to start and where to stop.
How to start, he will not say. Where to start, he says. Because it is very important. At times, many cases are lost because of over-argument. Over-argument. You will have anxiety as one case is true. Still, you have to resist your...
My lord, apart from that, during your lordship's tenure, bar has a very confidence that they will get some relief from this man.
But they are doing very well.
It's true, my lord.
I tell
all
you,
my
it's doing very well. The impression which
Still
I
there
gathered
sometimes
when I
anxiety is there
came
with the
here
lawyers.
is erased now. Everybody comes with preparation. Everybody argues this side, that side. We appreciate that. Take on.
That para 10 and 11 is there, my lord. Subsequently, I am considered as Jaco, Shripad.
That is, he has banked upon, learned single judge has banked upon.
That Maharashtra.
Maharashtra.
Yes.
Maharashtra is no longer there. That time. Correct. No, even there by that time it was loosened. 21 section, year 1921, Justice Khanvilkar's judgment has loosened this judgment. There is such a judgment. In my notes I have got. Take down. That's one. Very good. But this intra-court appeal by the employee calls in. Why two writ petitions, brother?
My lord, another employee jointly that he had not come. There is only one employee has come.
No, one employee is come. One is in the board.
Which is UWP?
3190.
That is Sharat Patra, your lord.
No. Which one is your
15098 or 15097?
15097, your lordship.
Whatever it is. This intra-court appeal by the employee is directed against a common order dated 29/10/2024, whereby his writ petition number 15097 of 2014 has been negative, relying upon certain decisions of the apex court. First off. Next paragraph. Learned counsel for the appellant employee vehemently argues that his client has been in service on a daily wage basis with effect from 15/12/2000.
14/12/2000 on daily wage basis at the rate of 40 rupees per day.
Semicolon.
Continue.
The wages came to be enhanced periodically, and that there is absolutely no complaint whatsoever about the performance of the appellant. First off, he presses into service the decision of the apex court in Jago in support of his claim that regularization ought to have been granted by the learned single judge. First off, learned counsel further submits that the decisions relied upon in structuring the impugned order are not much relevant in view of march of law relating to regularization, beginning from Uma Devi to Jago, and another is which is that latest judgment?
That is Dharam Singh.
Dharam Singh, your lordship.
Dharam Singh.
My lord, this is the judgment.
Dharam Singh refers to Jago also.
Jago and Shripad, both of them has been referred under the Dharam Singh.
Jago, Shripad.
All the things shall stand to 20 from 22 date on sanction post Petition with the state, fresh decision with the state is also informed. This state and the bishop shall create supernumerary post lines where there are no posts. Mr. Panda, this was the judgment. If there are no posts, create post and regularize that.
Where there are no posts.
Where there are no
posts.
That is supernumerary post.
Where there is a post, you have to regularize them in this one.
Only that irregular and illegal.
Or not.
Well, sanction post is there. But they are disputing that there is no sanction post.
Even then it will be good. Learned, see, from Umadevi to Jago and to Dharam Singh. What is that citation? 2025 INAC?
Jago.
No, that's Dharam.
Dharam Singh 2025.
25. First. So arguing, he seeks allowing of the appeal. They put a little AC. Learned AGA Mr. Mohanty vehemently opposes the appeals, making submission in justification of the impugned order of the learned single judge, on which it has been structured. First of all, he tells us that there being no sanction post, learned single judge is more than justified in having a view that courts cannot arrogate to themselves the power to create post. First, so contending, he seeks dismissal of the writ petition. Next paragraph. Having heard learned counsel for the parties and having perused the appeal papers, we are inclined to grant indulgence in the matter of reasons. 1. Law of regularization in public service is never static. First one, it has moved from Dharwad Daily Wagers case, 89 Supreme Court, 90 Supreme Court, AR 1990 SC, just look into that. To Uma Devi, State of Karnataka versus Uma Devi, AR 2006 Supreme Court, and then to Chago.
Thereafter, ML Kesari was there,
which has been reiterated broadly in Ramsey. First, if the entry point is not illegal, the service rendered would be irregular and not illegal. First, if such irregular service is rendered against a sanctioned post, then there is an absolute obligation to regularize the same if the employee has put in a long service. It's not less than 1 decade. First, if there is no such sanctioned post, the long service itself indicates requirement of such services, and therefore the state has to create supernumerary posts if need be, as rightly contended by learned counsel for the appellant. First, we need not travel so far in as much as records reveal that the appellant has been working against a sanctioned post. Which post it is?
What night
sweeper come.
Sweeper, night watchman come.
Watchman come sweeper.
Watchman come sweeper. That is watchman from sweeper. This aspect of the matter has been lost sight of by the learned single judge. First, that apart, the hallmark decision of Apex Court in Jago came only in November 2024. First, next first. The submission of learned counsel for the State Council, Mr. Mohanty, that the decision of the judge is well structured because it internalizes apex court decision in Maharashtra State Road Transport Corporation versus
राज्य परिवहन
राज्य परिवर्तन कर्मचारी संघटन
परिवहन
कर्मचारी
संघटन 2008 no 2009 8 SCC 556 and therefore this court may not interfere in the matter is bit difficult to countenance. First, that was a case essentially relating to power of the state to create courts. First, even first, in the light of Jago and Dharma Singh, that question would fail into insignificance. First, in Dharma Singh, the apex court at para 19 Roman 1 has observed as under. First, next paragraph. In the above circumstances, this appeal succeeds. Semicolon. The impugned order of the learned single judge is set at naught. Semicolon. Appellant's WP number so and so having been allowed, a writ of mandamus issues to which respondent?
3 and 4.
Respondent numbers 3. Respondent number 3.
Which
But to who?
After DAT, now it will be 2.
To the respondents to grant regularization or cause regularization of services of the appellant with effect from which date? With effect from the date he completed 10 years of uninterrupted service and grant all consequential benefits to him within an outer limit of 8 weeks without giving scope for contempt proceedings. What's made him?
Can some more time? Can
3
some
months.
more?
3
Because,
months. 3 months.
Because it is
within 3 months. Yes.
Sorry for that.
No. Doctor? Seriously, you have to reproduce this paragraph. Right. Yes.
Item 28, 29 have been adjourned. Item 30.
Item 13 is an appeal by the state, where the state is aggrieved by the order passed by the learned single judge in a review petition after the main order, the principal order, was implemented. Against the principal order being aggrieved, the state came in a writ appeal. In the writ appeal, my lord, the writ appeal was dismissed on the ground of delay, where the respondent participated even, and he knew that the writ appeal did not succeed. Ultimately, both the parties,
my lord, even the state who was aggrieved before the appellate court carried an appeal before the SLP. SLP was dismissed. So never at any point of time the respondent who was benefited by the single judge order raised his grievance. After 2.5 years, almost half years, a review petition was filed when the original order was complied with, and at the first date of hearing, without issuing notice.
What was the difference made in review order?
Yes, that is the because the state is agreed with that. In the principal order, my lord, paragraph 24 of that principal order, the
tell the foundational facts.
Foundational facts is, my lord, the promotion matter, where the honorable courts decided that a particular date a notional promotion benefit will be given.
Promotion from which post to which post?
Headmaster post, my lord.
Assistant teacher to headmaster.
Yes. Lordship may see paragraph number 24 of the judgment as page 56, running page 56 of the brief appeal memo. In conspectus of the above facts and guided by the precedents stated herein above this.
Now, what are the facts? Above facts means which facts?
That little threadbare discussion is there, my lord.
Just tell that.
He was appointed as an assistant teacher in 1975.
Yes, my lord.
1/11/1975.
1/11/1975.
And got promoted in the year 1986 to the post of headmaster after having acquired the BEd qualification.
No, my lord. No.
Yeah.
26.
My lord, just I am telling the brief facts. I was representing the petitioner in the lower court. The petitioner was appointed in 1975. And one Gagan Chandra Das was appointed after that. That is in 1977. Since Gagan Chandra Das acquired BEd qualification earlier to the petitioner, he was promoted to the rank of headmaster in 26/3/93. So that made all
93 or 83?
93. 26/3/1996. Well, that was challenged before the tribunal by various senior teachers. So the tribunal allowed the applications. Well, similarly, thereafter the matter was carried to this court confirmed, and some order have been complied in 2018, some order, and these petitioners, those who are headmasters and senior to Gagan Chandra Das, also approached your lordship. Your lordship first directed this to consider their case in the light of the other cases. So their case was rejected on the ground of delay and laches, against which we preferred a writ petition. The writ petition was allowed, taking into consideration that paragraph 4, my lord, consists of there are four the ordering portion divided in 4 parts. First part is Gagan Chandra Das is junior to the petitioner, and petition he was given promotion to the rank of headmaster on 26/3/96. My lord, and this petitioner admittedly senior to them. So therefore, there is a direction to consider the case of the petitioner to the rank of headmaster with effect on 26/3/1996. And the actual financial benefit will be given from the date of promotion. But that was the direction. Your lordship may kindly say. So, my lord, they filed an appeal. Writ of intra-court appeal was dismissed, against which the prefers SLP. SLP was dismissed. After SLP was dismissed, they complied the order on 31/7/2024. The single judge, honorable single judge order was complied. That order was passed on 21/12/2022.
1 second. Single judge made order on
21/12/2022.
Whether this was challenged in
this was challenged in the writ appeal. Writ appeal was dismissed.
WA number 1897 of 2023.
That was dismissed. That against that
1897 of
1897 of 2023.
Dismissed on
8/10/2023.
SLP
have a perusal.
SLP. No, we agree with you.
SLP was dismissed in August.
SLP number.
SLP diary number. Just
SLP diary number, my lord, 13349 of 2024. 13349 of 2024.
Dismissed on?
Dismissed on, my lord.
10-23.
23.
No.
It will not be 18,
No.
23.
6/5/24.
Yes,
6/5/24.
Yes, sir. 6/5/24. My lord, thereafter.
1 second.
Yes.
When they implemented the order?
They implemented the order on 31/7/2024. And
Sorry, you have to process, no?
Yes.
When you say implemented the order means 10 questions will arise.
Yes.
What is meant by implementation?
Yes.
What is the effect of implementation?
Yes.
You have to little give time to the judges.
My lord, SLP order 6/5/2025, that may not be correct, my lord.
No, which date?
Because that date we are not having, but the 6/5/2025 is the review order.
No.
Yes.
SLP order I am just giving. 31/7/2024. No. 31/7/2024, that was, sorry, SLP diary. 6/5/2000.
6/5/2024.
6/5/2024, that was dismissed.
Then 6/5/2024.
Yes, I have mentioned in paragraph 3.6.
He is over anxious. That is the problem.
No, I am sorry, man.
Order implemented on
31/7/2020.
Implemented means what? What
My
date?
lord, that I am just submitting. My lord, before that a contempt petition was filed. I filed a petition after dismissal of the
SLP.
No, not SLP. After dismissal of the intra-court appeal. So they said that since a contempt petition was adjourned because they said that SLP was pending. So when the contempt petition was placed before the Honorable Single Judge, they said that we have complied the order. That compliant order was I objected because what they said that they give me the financial benefit with effect from 31/7/2024. That is the day when they after dismissal of the. But the order is.
You said something again wrong.
Yes. No, I am not.
Second part you said dismissal
31/7/2024. They complied the order of the Honorable Single Judge. That what they have mentioned in their reply affidavit in the contempt.
But just 2 minutes ago you said it is implemented on 31/10/2024.
No. 31/7. 31/7.
Therefore, I told you are in anxiety.
No. I'm sorry. 31/7.
Two dates you have changed now. You changed the dismissal of the SC.
6/5.
It is 6/5/24. But
Yes.
you said some other date again. We removed and
my friend.
All right. Order implemented on
31/7/2024. They said that the financial benefit will be given to us. The actual financial benefit will be given to us from 31/7/2024. That we said.
Why 31/7?
They said that is the date of promotion. Because they implemented that order, that is the date of promotion. But your lordship, in paragraph 24, the Honorable Single Judge has said that I will be given promotion with effect from 26/3/96.
It is said like that.
Yes.
Where is that take us to?
Your lordship, I have quoted in my objection, or your lordship kindly
take us to the order.
Yes.
Take us to the order itself.
Annexure.
Notional promotion, that paragraph page, running page 57.
Yes. It's 6, it starts from 24.
Come to 24.
Paragraph 24.
Accordingly, the opposite parties are directed to come to 57.
I'm just reading paragraph 24.
Not fully. We have already read.
Your lordship,
accordingly,
the opposite parties are directed to consider the notional promotion of the petitioner with effect from 26/3/96 and the financial benefit be extended in his favor from the date of order of promotion to the petitioner to the headmaster. So, my lord, when I am promoted in 1996,
I will retire, my status on the date of retirement will be a headmaster. My status, because I was an assistant teacher, if I will be given promotion notionally with effect from 26/3/96, on the date of my retirement, my status will be retired as a headmaster.
Correct.
So, my lord, my pensionary benefit as a headmaster scale of pay, I will get from the date of my retirement. They say that order of promotion from, that is what the honorable
last sentence.
They say that the financial benefit from 31/7/2024.
Why is that date? We are unable to understand. What is the logic behind that date?
And Honorable Single Judge has just corrected the word date of promotion to 26/3/96. That is what the
96 or 93, sir?
So 93, my lord. 26.
You have been telling 96, 96.
Sir,
we are correct.
I'm sorry, madam. 26/3/96.
93.
93. Sorry. Again, sir. Sorry.
96.
No, 26/3/96.
All right.
So the single judge has just corrected that, but from the date of promotion, instead of date of promotion, he said that 26/3/93. That is what, and that is now a change the nature and character of the direction.
In the writ appeal, what is the reasoning?
Delay on the delay ground, it was dismissed.
Once writ appeal is dismissed, do you have that copy of the order?
That I have applied to the laws.
Because once it is a detailed order, this order will merge into the order of the division bench. Because of Muhammad Nuh versus UP.
No.
We are saying, don't say no. Process what?
Yes. As your lordship said, that is right.
We do not know. We process it. The judge is saying,
yes,
like this, can it be right? But we can say like this. If I am saying, we say it on the basis of judgments of the Supreme.
Yes,
especially Muhammad Nuh versus state of UP. No, that's not. It is a very old judgment. 58, 59, something like that. Meantime, more than 200 members were passed, therefore the reflection suffers from the that's been put to much return to something latest layer of circumstances. It is dismissed on delay. Therefore, there is no merger.
Yes. And if your lordship, one minute, my lord, that day, on the day when this review petition was, the contempt petition was going on, the State Council hand over me a copy, whether that copy is also available here or not, to me and to the court. This is the thing. On instruction, they said that we are going to correct our mistake and we will give it from the date of retirement. Because I have retired in 2007. So this was the instruction they passed.
That how you got this?
No, they have given to me.
To the court?
Yes,
the
court, they have given a copy to me also.
Whether the court has a...
I don't know whether they said this is given in the court and they have given.
You Xerox of that.
I have a copy. I have another.
You have a copy. Where is
that is paragraph 4, your lordship, mechanics.
Paragraph 4.
Because,
1 second. with effect from the date of his retirement.
Yes. That is what I want.
Instead of the date of order of promotion.
Yes. So that is what, that is, they have complied in respect of others. In respect of others, they have done it from the date of retirement.
That result is brought about by correction by the learned single judge.
Yes.
It is virtually reverse stand.
I do not know because that is not a part of record of
No,
review.
this
address to you.
Look into.
This is address to the state.
They will not give you. They don't give to the two judges at all unless two judges insist. One copy will be given to us and we should be sharing it. That's the culture here. Lot of poverty.
It was communicated to the office of the Advocate General.
Yes. This is signed by how many of our officers? This you cannot dispute.
I had not seen. Just now I'm seeing, and I'm endorsing that it's in a communication to our office.
Yes.
By the department.
Communication, privileged communication between client and the lawyer.
That's the.
Others cannot take his true. But you, if you only give it to them,
I do not. That I cannot say. He can.
There is one section in evidence.
That the privileged communication.
Privileged communication between lawyer and client.
That's a privileged communication. That's a category. That's a category. The immune from.
They have given a copy to and also
whether in the content proceedings this is mentioned.
No. I don't know because they have said. His Lordship said that since we have already passed this order of that correcting the date, if you want to correct, you can comply the order and give a fresh compliance affidavit.
Where is that order?
Well, that is not there in the contempt.
No, we want to know where is that order, contempt order.
Contempt order, I don't have.
Which is that contempt number? Give
contempt number. Yes. Contempt number.
Take up that contempt order.
Contempt number is. Your Lordship can check from the. You want to see number 8746 of 2023.
8746 of 2023.
Yes.
Take out that order.
That order was also filed on the same day.
Contempt case number.
CONTC 8746 2023.
Is it done?
No, it is still pending.
It is still pending.
Because of this appeal, the Honorable Single Judge has adjourned the matter.
It's only agenda.
Yes.
Our writ appeal is on the premises that first we are not given any opportunity to file any response.
Finally decided.
No response to the review petition. Review petition we could have opposed on the ground of inordinate delay because it was filed. It should have been filed within 30 days. It was filed after 2.5 years. At least two years delay was there.
Well, is it review? It is a rectification.
No, review. Review petition number is there.
The number is there. The question is.
Maybe rectification or Honorable Single Judge rectified. And
it fits into 151 or 152.
Nomenclature is a review.
152. Go to CPC. You might have.
Correction of error. 152. I know, but it has been.
It has been review because it does not fit into the parameters of Order 1 and 2 of CPC, which are made applicable to your writ proceedings.
Then I know that.
Therefore, your filed review perhaps may not be. It is 151 power.
152.
Maximum
and 151.
151.
Read with 151.
That question is not. If it is 151, 152, there is no limitation. For review, there is limitation.
Yes. But
so consequences are there.
Earlier, we were seeking this type of reliefs. We are filing IA. Now, Your Lordship
is the right
stopped IA because of no disposal. After disposal of the case, no IA is maintainable. Functus officio. So the power was invoked under 152 of the CPC. But nomenclature is review. And our point is that if the person has not worked in the promotional post, no work, no pay will be applicable.
But you said in your letter.
No. That letter will Lordship may not take into consider because it's a privileged communication, and also that letter also says at paragraph 3 that while this office with a condition, the actual financial benefits will be extended in its favor from the date of order of promotion of the petitioner to the post of headmaster. That is the paragraph, last line of.
No, if it were to be only privileged communication, we would have agreed. It is sent to all other officers.
It is sent to all other officers
for implementation.
Yes, that only I am saying that is the last line, Your Lordship may see that the headmaster notionally would have given a promotion. We have complied with the order of the learned single judge by extending notional promotion from 26/3/1993. That is the date of promotion of Sri Gavan Chandra Das in the scale of so and so. This officer number so and so, with a condition that the actual financial benefits will be extended in its favor from the date of order. If he is relying upon this will go against him, my lord.
No.
No.
Kindly come to paragraph 4.
Paragraph 4
of your communication.
That basing upon the above promotion order, the compliance affidavit has been filed before the Hon'Ble Court of Orissa, High Court of Orissa, on dated 9/3/2025. In this regard, it is submitted that in response to the discussion made with learned AGA on 1/2025, and as per advice, this office has been requested to Additional Secretary to Government, School and Mass Education, by this office letter number so and so, to issue necessary government instruction about allowing the actual financial benefit in favor of the petitioner with effect from the date of his retirement.
Yes.
Instead of the date of
promotion
of order of promotion.
Your own officer said that.
Soon after receipt of the instruction from government, necessary step will be taken for allowing financial benefits. Then, my lord.
Absolutely.
His date of retirement is, my lord.
Date of retirement is when you retired, brother?
30/9/2007. 30th September 2007.
30 September 2007.
Yes. My lord, I have in my objection, I have annexed certain compliance order passed by them in respect of other.
Giving
benefit on the date of retirement. Yes.
Now, my lord,
so basing on that, my judgment my cases were allowed.
Lordship will take into consider 30/9/2007. Then, my lord, it is a third case, my lord. It will generate a third case because in review, the Honorable Single Judge has ascribed that date as 24.
93.
93 no, notional. Means he will be promoted, and on the date of retirement, status will be a headmaster, and his retirement benefit will start from that date.
That is clarified, you will be happy.
Yes. That is what they have said in their instruction.
No.
We are not claiming salary.
Notionally, they are.
Yes.
We are not
financial benefit.
No, financial
retirement.
benefit. No, financial benefit. Otherwise, what is the purpose?
He has worked, he is a teacher.
Because your lordship kindly see.
No financial benefit during the period of no work.
Why can't you make benefit of judges' views now?
No.
Unless
some person are dead now. Out of these are batch of cases filed. At the time of writ petition was allowed, some 10 persons were alive, but out of them 2 have died. And if their spouses will also not get, because if they are dead, this benefit, if the retirement benefit they will not get from the date of their retirement, the order is totally meaningless. And these people are also 79, 80, 81. Now. And order has been passed since 3.5 years back.
Actual financial benefit be extended in favor of the 26/3/1993. That is the.
No, not 93. Financial benefits will be from the date of his retirement. We'll make it clear now.
Yes.
You have made the appeal on the assumption
That they will be given salary.
even with effect from 1993, financial benefits are directed to be paid. It is not. We make it clear.
Yet you also correct.
We'll make it clear.
Grateful.
That is also the view of the Honorable Single Judge.
But it was not meant.
Take one.
And one more request, my lord. Your lordship may say that since 3.5 years in the meantime, they must comply the order.
Okay, I will say that.
Yeah.
I will say that. This appeal by the state, intra-court appeal by the state, seeks to call in question a learned single judge's order dated
6/5/2025.
6/5/2025, whereby
Passed in
RVWPET number 86 of 2025, filed by the respondent employee, now retired, whereby the learned single judge has clarified, we'll say that. His order dated 21/12/2022 to the effect that the financial benefits of promotion granted to the respondent employee would be with the effect from date of his retirement, that is, which date?
That is
The 30th September 2007.
30th September
30th September 2007. I retired.
2007.
My lord, but there are a batch of cases were disposed of. There are different date of retirement of different.
In your case.
No.
In only in your case.
No, on 21/12/2022 order, a common order was passed in respect of 10 writ petitions. So the date of retirement may be varied from.
Correct. In your case, it is 30 September.
Yes.
2007. Therefore, to the effect that we wrote, we are unable to understand that order. Due respect. Yeah. 30 September 2007. Next paragraph. It is so very good question. Yes. Learned AGA appearing for the state, appellant state, argues that when the effective date of promotion was stated to be 26/3/1993, on notional basis in the original order whereby the writ petition was disposed of, comma, it was not open to the state, the learned single judge to alter the date to the advantage of the respondent and to the disadvantage of the appellant state, especially when writ appeal number 1897 of 2023 filed against the said order was dismissed by the coordinate bench on 8/10/2023.
1810.
By the division bench, my lord.
By the division bench.
By the
1810.
By the division bench. Writ appeal was dismissed by the
Division bench is not this bench, another bench.
Yes.
Yes.
Therefore, we said coordinate
All
bench.
right.
1810/23.
1810-2020.
1810/2023. First up. He also argues that the review petition itself was moved after broking about a delay of about 2 years, and therefore that could not have been favored without donation of delay, and also without giving an opportunity of hearing to the appellants. First one. Learned counsel representing the respondent, per contra, resist the appeal, contending that the learned single judge has only rectified mistake in by making it clear that during the period between between 26/3/1993 and 2007, comma, no financial benefit would accrue to the respondent. However, the said benefit shall be payable to him with effect from the date of his retirement. First off, he passes on letter number 5633 dated 5/5/2025 addressed education officer Kyunjhar to the office of additional government advocate in connection with respondent's contact number 8746 of 2023, pending contact number 8746 of 2023, pointing out the contents of para 4 thereof. First one, next paragraph. Having heard learned counsel for the parties and having perused the appeal papers, we decline indulgence in the matter for the following reasons. Next point. Learned single judge at para 24 of his order dated
21/12/2022
had observed as under. Next paragraph. The respondent, full stop. The writ appeal 1897 of 2023 preferred by the appellant's hearing came to be dismissed on 18/10/2023 as mentioned above. First up, even SLP diary number 144 of 2024 met the same fate at the hands of the apex court on 6/5/2024. First up. Subsequently, the order of the learned single judge was implemented on 31/7/2024. However, the benefit of promotion, financial benefits of promotion were not accorded to the respondent, at least with the effect from date of his retirement, although the effective date of promotion was 26/3/1993 by notion. First time. Therefore, he had moved review petition number so and so, subject review petition seeking rectification. First up. Though it is styled as a review petition, learned single judge himself has alternatively stated in his review order, so-called review order, clarification of the directive portion inwards of the judgment dated 21/12/2022. First up. Even on merits, a petition can be called as a review petition if it broadly accords with the parameters of Order 47, Rules 1 and 2 of CPC 1908, which in substance do apply to the writ proceedings for the extant rules of this court. First up. However, the petition broadly fits into the contours of section 151 and 151 of CPC. 152 of CPC, correct. 152 of CPC. First up. For such an application, there is ordinarily no limitation period. First up. Therefore, the appeal structured on a premise of review has to fail. First up. Next point. Learned counsel appearing for the respondent employee is also justified in resisting this appeal by banking upon paragraph 4 of District Education Officer's letter dated 5/5/2025, which has the following text. See this. We'll produce this one. Below that, the contention of Mr. Panda that it is a privileged communication between the counsel and the client. Which section, brother? Which section of evidence segment? Privilege. and therefore may not be looked into, is bit difficult to conceive, in as much as the letter is addressed to other officials also. First up, even otherwise, on the contents of the said letter, one can safely say that privilege of the kind does not avail. First up, 126. 126? 126 of Evidence Act 1872. Erstwhile Evidence Act 1872. Yeah. Last point. The last contention of Mr. Panda, that order of the learned single judge dated 2022, having merged into coordinate benches order dated 18/10/2023, rendered in writ appeal number 1897 of 2023, followed by dismissal order dated SLP dismissal order dated 6/5/2024, learned single judge could not have entertained the review petition, again is unacceptable to us. First up, neither the coordinate bench nor the apex court said even a single word on the merits of the matter. First up, writ appeal was dismissed only on the ground of delay. First up, SLP was dismissed at the daily stage. First up, therefore, the doctrine of merger, is it Muhammad Noor versus UP? Muhammad Noor. Doctrine of merger in terms of state of UP versus Muhammad Noor, AR 1958, 86 is not applicable, is not invocable. Therefore, it was open to the learned single judge to rectify the mistakes, if any. First up, there are decisions of the apex court which hold that even after dismissal of the SLP on merits, mistakes of the kind can be rectified by the court ex dubito justitiae. Ex dubito justitiae. First one. Next one. In the above circumstances, this appeal fails. First one. The permitted to give effect to the impugned order by having financial benefits to the respondent with effect from the date of his retirement, into brackets, not for the earlier period, bracket complete.
That is from 39/2007.
Earlier period, that is from 39/1990. This will save you. This reservation
2007.
No, 93.
No.
26/3/1993.
You
26/3/93
submission altogether. Sir is writing properly. Not the earlier one. So it is already mentioned above. Now only with effect from 30th
retirement you have to.
Yes, retirement date I am only mentioned.
Yeah. That's not earlier.
39 to
not for the earlier period.
93.
Only I have to mention the retirement date.
Bracket complete.
Because
within an outer limit of 8 weeks.
My lord.
8 weeks.
Yes.
First one. Therefore, that content matter will be we'll observe that he can request it.
I will withdraw, my lord.
Why withdrawing? Again, one more content if they do not pay. First one. The pending case in contact 8746 of 2023 may be heard by the jurisdictional court after the expiry of 8 weeks.
Respondent may take benefit of this contempt petition.
They will- No, my lord. Yeah, now the order is complete. Now, with your lordship's permission, may I say a word? My lord, this, the instruction which I handed over to you, that the State Council handed over this instruction, and it was told to the Honorable Court that if this date is clarified and in view of this instruction, we are going to.
That I am not privy to that.
No. The council, I was present there.
No, he was not there.
Thereafter, what has happened,
That is
I need
not
not
record.
This,
That is not
because
record.
that was
I am not privy to that.
clarification. We went, my client went with the order.
No, we have taken it because copies have been served on other officials.
Yes.
That is how we have taken.
Otherwise, he would have been entitled to privilege.
After what I said, that this was the discussion in the court, and basing on that discussion, his lordship has passed the order. My client has gone with the order to the.
With your lordship's permission, my lord.
Thereafter, what happened, I need not say to your.
This is over. Yes.
My lord, with your lordship's permission, because on my mention, my lord, the content proceeding, since it is pending before the Lord CAD on 3rd of February, the matter, even though it could not be reached, my lord, on the last occasion, today it was listed, it is at serial number 35. But I am unfortunate, my lord, it could
Who is
not.
your opponent?
My lord, Mr. John Major.
Don't precipitate the content matter till next date of hearing.
Thank you.
All right. We'll fix a date also. Learned panel counsel for the. You are
ESIC,
for the
ESIC.
State Selection Commission.
No, my lord, it is for the ESIC, Employee State Insurance Corporation.
You are panel counsel for various other bodies also, rightly.
So, my lord, I am also additional court advocate also.
Okay.
My lord, I may be excused for my anxiety. I'm sorry.
Nothing like that. We are all brothers. Brothers should speak something against each other. Otherwise, how are you going to demonstrate the brotherhood?
Yes.
We will be strangers. We are not strangers. Therefore, we talk so much with each other. Nothing like that. Nothing remains in the heart. Yes.
Yes.
Is that one, no?
Item 35, madam.
Matter is adjourned at the request of learned counsel.
Maybe
Tomorrow we have difficult. Tomorrow we are not seeking.
Monday. Your lordship is a transfer matter.
Yes, my lord. It can be on Monday, my lord. It is second.
Honorable Supreme
Because
Court
the-
judgment, my lord. Honorable Supreme Court judgment thereafter, my lord.
We'll have
Monday, your lordship.
Thursday we will have that. Thursday.
Ajay, lord.
Top
Yeah.
of the list has been searched.
Put it in the top of the page there. But you have done all this matter on that day, Thursday, na? It will be 5th.
And my lord, my lord, only one more submission.
I suppose that shall not be precipitated.
Most.
All this matter on 5th of February 2026, as requested by learned panel counsel appearing for the ASIC. And till then, the contempt proceedings pending before the CAT be kept in.
Shall I give the number, man?
Yes, contempt proceedings in. Do you have?
51 of
We can make this.
51 of 2025, madam.
Right now. Shall be kept at a bay.
Most of.
Yes.
No further adjournment, lordship. That order may be continue.
My lord, question of I am making submission, my lord, to take up the matter. Where is the question of adjournment?
This is the issue. After the order of the Supreme Court, they have filed this case.
I can also demonstrate.
Item 36. Item 26.
26.
36.
36.
Lordship may take up next week.
Next week we have difficulty. We'll call it week after next. Week after next.
Pardon, my lord. Item 33.
31, my lord.
Item 31, the next item will also.
31.
Yes, my lord. Next item.
My learned friend has given me two orders of the honorable tribunal, wherein he says he asserts that this petition, this opposite party is covered by that order. If you allow me, lordship, allow me only 1 week time, I can take instruction and lordship fix up a date. This matter, if covered, this may be disposed of in that.
11 February.
My lord, obliged. Obliged.
34, my lord. Item 34. 32. Electricity supply.
That's 32. Your lordship had on the last occasion had asked me to produce some documents. And my lords, I prepared the counter. It's executed to be filed. It's there with me. If your lordship permits, I'll file the counter. The explanation and the documents are there in the counter.
You serve a copy
I'll
on the
serve a
other
copy to
side.
my learned senior and I'll file it.
We will have this matter on Monday. 4th of
Monday.
Monday we have difficulty because 2, 3, 4 we have already fixed many cases. 4, 5. Huh? 4, 5. Up to 5. Then 6 we can have. 6 will not be there. 6 will not be there. You have it on 4th. I will have it on 4th.
Item 34.
Because he said urgency of power supply, etc.
Item
Yes.
34.
34.
That is recovery from the pension matter. And it is covered by all the CAT from different states and also by the Honorable Appeals Court. So can be taken.
So we'll take up this matter on 12th of February.
Item
requested.
Item 33, my lords. In this case, yes, my lords. 33. I am for the opposite party, my lords. I am for the petition. Matter has been settled between the bank and the borrower. Settlement is going and the payment schedule has been, the next payment schedule is on 20th of February. So I pray any day in the month of March.
We will dispose of the petition to seek revival.
Second payment has not been made.
Suppose if he does not make, the whole matter will go.
Lordship may keep it lying because.
I'll give you an outlet also. Now settlement has taken place between you. Correct? What are the terms of settlement?
70 lakhs is the settled amount, and out of that we have paid 60 lakhs.
You have already paid 60
lakhs, and next 10 lakhs is to be paid by 20th of February.
You pay that.
Yes. So
and in the event he does not pay, seek revival of this petition. We'll also make clear settlement fails. That's all. Both the learned advocates appearing for the party, that matter has been settled between them, whereunder the petitioner has to remit another sum of rupees 10 lakh.
Opposite party.
OP has to remit another sum of rupees 10 lakh to the bank. Which is that bank or what is that?
Finance
financial institution. On or before?
Next part is 20th of February.
20th of February 2026. 26. First time. Suppose if you do not pay, then what will happen? You are the OP.
My lords, the compromise will fail.
In the next paragraph. In the event,
my lords, I am the opinion number 2. My lords, I have already paid 60 lakhs. I am the opinion number 2 borrower.
You have paid 60 lakhs already.
Yes, I have paid 60 lakhs and the is of 10,000 and that has to be 10 lakhs. 10 lakhs and that has to be paid by end of 20th of February. Another date, my lord. Lordship may keep it pending.
Say 28th of February. So that end
last week of March.
No, you only say agreement is on 20th.
20th.
I am still we are changing because G is saying something.
He is telling that let the matter be kept pending.
No, we are not settlement has taken place. We are not keeping
on 30th of December we paid 60 lakhs.
Yes. What do you? Filling which the coercive action follows. First, with the above observations, writ petition is disposed of.
But if something, some untoward situation happens, then we can seek for extension.
No, that is there. You make application here. You make application here.
Yeah, that may be.
No, we will not say anything. That we will not pay only. First, your interference, brother was. They should not interfere only. Yeah. This board. Okay.
Obliged.
Disclosure.